Hello, hello.
Please be seated.
Gonna start listening to the trial again, or the hearing. Oh gosh, not the trial, the hearing. Court TV, you are no longer on a live break, or a break. You're live. Take it off. Click it.
State ready to proceed?
Ready to proceed. I think they're still getting the defendant ready to sit down. But
Very good. We certainly will wait on that, Mr. Harfootman.
Your Honor, once he's seated, I have a matter I need to put on the record.
All right, sure.
What's the matter now, Dick? Court TV, take the words off the screen. Thank you.
Yes, sir.
Your Honor, we last week discussed the standard by which you would proceed during this proceeding and evaluate the evidence. We argued that you should use a case called Bremer. You rejected that. But under any standard, as I understand it, the burden of proof is on the defendant to show certain statements were made or certain conduct happened. So far, Your Honor has called as court witnesses 12 witnesses. We were not offered the opportunity to cross-examine them. And so we've not had the opportunity to present any evidence whatsoever. And before the state presents evidence, I believe that we should be able to call witnesses. And I would ask the court to allow us to present some evidence before the state comes up with rebuttal. And by the way, under the cases you cited, they have no affirmative obligation to present anything at this point. There's no requirement they present anything. So I would ask you to allow us to call a witness or two before you make a decision as to whether or not they need to call a witness.
The state?
Your Honor, we obviously have argued very extensively some of the cases, and I think the South Carolina jurisprudence is very clear that while an evidentiary hearing is appropriate, and that's what we're doing here, that manner of inquiry is purely within the discretion as the trial judge sees fit. This is not a criminal trial where we're here with a jury to present the normal criminal trial process. This is a inquiry that is very much directed by the trial court and what the trial court thinks is appropriate. And so the state certainly is comfortable with the inquiry the court is conducting. And my understanding is, as far as putting up Ms. Hill, this is the manner in which the court wanted that evidence presented. And so we're happy to comply in that regard. But we think that this inquiry is within your discretion, and we have no issue with the manner in which Your Honor's proposed to conduct it.
Please, the court, Your Honor. Certainly, the conduct of this hearing is within your discretion. What is not is who has the burden of proof. We do. And we can't meet that burden if we can't call witnesses. And so I'd ask the court to allow us to call witnesses. And if at the conclusion of us presenting those, you believe the state is required to present evidence to contradict that evidence, or in some way, I'm not quite, since Remmer is not the standard, I'm not quite sure what they have to prove, but that's an argument down the line. I believe we ought to be able to call witnesses now, and we have witnesses which would substantiate the burden we have to show you that statements were made by the clerk of court, and that those statements had impact on a juror or jurors.
All right. I've got a couple of reactions to that. Number one, the pretrial was the time to figure out exactly what we were going to do here. And I think it comes at the last minute for you to now come and say, we want to present witnesses. You briefed the matter of witnesses. We had a long pretrial. After I made my rulings on what I thought the scenario was that should be used based on State versus Green, you lodged objections to that, but you did not offer at that time any information about who you wanted to call, other than this lengthy filing in one of your briefs. It comes pretty late in time for, in my view, for you to do that now. Second thing is, I gave the defense a big break when I allowed you to be the cross-examiner and the state to be the presenter of Becky Hill. She's really a witness that each side needs to prove their view of what happened in this matter. The state puts her up to try to show that there was no impact by anything she said, and that some of the things your witnesses say were said, she says were not. So there's a conflict in the evidence there. I'm not going to rearrange the situation and go to any witnesses of yours right now. I'm going to see what Ms. Hill has to say. And then afterwards, we can talk about whether there's any need for any other witnesses.
Your Honor, just factually argue this with you. We did not understand. We assumed you'd adopt Remmer because that was.
Well, I don't know why you assumed that.
Because
when the
that's
South Carolina Supreme Court said very clearly that we do not go by the guidance of the 1950s case of USB Remmer.
We do not believe that's what Justice Kittredge has said.
They said it straight out, as clear as a bell can be, but I've ruled on that.
Yes, ma'am.
And,
all I'm saying
and the South Carolina Supreme Court's going to have plenty of chances to decide that they want to modify Green.
well, when we were somewhat taken aback by a ruling as a result, and that ruling came at a point where we didn't know what these witnesses were going to testify to. So we now, and by the way, you've set aside 3 days for this. What's the hurry? This gentleman is facing life with no parole. We should take this in a very deliberate way. He's got a 14th Amendment right to ensure that he had a fair trial.
Arguments should have been made before this time,
Why?
Mr. Well, Mr. Harcourt, I've told you how I'm going to handle this thing. Your objections are noted and they're on the record. But right now, what I'm going to do is what I said I would do. We're going to call Ms. Hill and see what she has to say. I have no idea who all you want to call as witnesses or whether they're here in the courtroom at the present time. But we'll get to that after Ms. Hill testifies.
Yes, Your Honor.
All right.
Just let me bring to your attention this email.
I think his normal shenanigans are not working with Justice Toll, and the things that he's used to doing just are not, they aren't working with Justice Toll. She's not interested in entertaining his semantics, his theatrics, and yeah.
Let me go to a little something here that I'm just getting an email on. And put this on the record right now. I have a communication from Mr. McCullough that's only, that is copied to Mr. Harpootlian, Mr. Griffin, Mr. Waters, and Attorney General Wilson. And basically says his client, Juror Z, wants to enhance the testimony she gave with some sort of affidavit that he wants me to look at, and I have looked at. I want to hear from the state and the defense, but I can tell you, I'm not inclined to get back into the testimony that's already been taken by these jurors. Her inconsistencies, whatever they are in the record. And she now wants to have another bite at the apple. I'm not at all enthusiastic about that. But I will hear from you, Mr. Waters, first.
Your Honor, the jurors testified. The court conducted the inquiry that needed to be conducted. She answered the questions. I would agree with Your Honor that multiple bites at the apple are not warranted. So we believe we should proceed forward as the court has indicated.
All right. Mr. Harpootlian?
Your Honor, I'd note two things. The first thing is we asked to be able to examine this juror. You denied that request. Number two, She's not our witness. She's not Mr. Waters' witness. She was the court's witness and a juror that, and you commended all of them on their honesty. She's attempting to be honest. This process we're going through is an effort to seek the truth. This is the truth. I don't understand why it can't come in.
I think I understand what your position is. Mr.
So we'd
Parker.
ask you to make it a part of the record. You can say you're going to consider it. You're not going to consider it, but it should be a part of the record.
Well, I'll give some thought to whether this thing should be a part of the record, but I can tell you this. Witnesses don't get to get on the stand and testify under oath and then seek to add or change or deal in any way with their testimony. Those questions were very open-ended questions that asked for her responses, and she gave them. If they're inconsistent, she can't come up now and try to close the loop of consistency by some additional testimony. I am not thinking about allowing that to be done.
All due respect, Your Honor, we believe, and we said at the time, the way you questioned her put her in the position of saying, yes, that was my verdict then. We think, and we couldn't examine her, and Your Honor, to say now that this affidavit doesn't accurately depict her position is to deny fact, the truth.
You've already said that once. I note your position on that matter, but I decline to adopt it. All right.
We'd make this an exhibit as a proffer for our case. This affidavit, we proffer it for our case. We have the burden.
I'll give some thought to it. I'm not ready to deal with that right now. I have looked at it just in the moment right before I put it on the record. I'll do some research about that, and we'll close that loop before the end of the day.
Your Honor, again, I indicate we have 2 more days. We don't have to wrap everything up today. Thank you.
Yes, sir. All right. Mr. Waters.
Thank you, Your Honor. The state calls Rebecca Hill.
All right.
Here we go, folks. Yeah, I very much find that fishy. Why are they going so hard? Why is Harpootlian going so hard for further testimony from Juror Z? Her attorney, McCullough, was in the audience for Murdaugh's trial pretty much every day of the trial. So do with that what you will. Delayed dick. You really should. Digging around, man.
The testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Is she going to plead the fifth?
Good afternoon, Ms. Hill. How are you?
I'm fine.
I want to get started, if you would, if you could state your full name for the record and spell it for the court reporter, please.
My name is Becky Hill, last name Hill, Hill.
All right. If you would, just give us, you're currently the clerk of court for Colleton County, is that correct?
That's correct.
And just very quickly, if you would, what year were you elected as clerk of court?
At the end of 2020.
At the end of 2020?
Yes.
And prior to that, did you have any involvement or experience with the state judicial system?
I did.
And could you tell the court what that was, please?
I was a South Carolina official court reporter for about 14 years.
All right. And were you, in being an official court reporter, you would serve in the courtroom, which is Ms. Harris is here today. Is that correct?
That's
what
correct.
Was your, and was that primarily in the 14th Circuit?
It was primarily in the 14th Circuit. However, I did travel throughout the state.
Did you have any other experience in professional experience prior to becoming a court reporter or clerk of court?
I was a court reporter freelance for 2 years before that.
Okay. And then any other professional pursuits you've had over the course of your career?
I was able to be a middle school teacher. And I worked for the Board of Disabilities for a few years as well.
Let me go ahead and just kind of get straight to it. In your capacity as clerk of court and in your previous experience being a court reporter, were you familiar with the rules that apply to court staff as it comes to interactions with jurors in the course of a criminal trial or a civil trial for that matter?
Yes.
All right. And could you tell the court generally what those rules are as far as what contact is permissible and what contact is not permissible, just very quickly?
The judge gives the law and gives the instructions for a jury, and the attorneys will state their opening argument, their opening statements, their closing arguments, and basically the clerk of court and anyone else, court reporter, we're there to, my understanding would be to make sure that everyone's taken care of. Do you need some Kleenex? Do you need some water? Different things like that, just to make sure that they're taken care of.
Is it common for clerks of court to have interaction with jurors during the course of a trial to see to those various logistical needs that you just described?
Yes,
And did that happen in the Murdaugh case?
it did.
And can you give us an example of some of the logistical things that you or other things that you would see to deal with any needs that the jurors may have? I mean, did you provide them food, coffee, make sure they were comfortable, things like that?
Yes, all of that.
Provide blankets for them if they were cold?
Our courtroom was very cold in Colleton County, yes.
Did you provide them with aspirin or Tylenol if they needed, make sure coffee and snacks were available?
Yes,
Did you take lunch orders for them so that they were fed each day?
yes.
At any time, did you interact with any juror in an attempt to influence their view of the facts in the State v. Murdaugh case?
No,
All right. Now I want to ask you some specifics about that and some allegations that have been raised. At any time, did you tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys?
I did not.
At any time, did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time, did you instruct the jury or tell the jury to look at his movements?
No,
At any time, as the jury moved to deliberate, did you tell the jury this shouldn't take long?
no,
At any time, did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
no.
Let me ask you if you ever made any comment to the jurors about the fact that the defendant was going to testify. Did you have a conversation in the presence of the jurors prior to the defendant testifying about the fact that he was about to testify?
It wasn't directly related to the jurors. I was talking to Mr. Bill, who was our bailiff foreman, our bailiff over the jury, and I was talking to him about that.
All right. And what did you say?
I told him what I had just come from downstairs telling my security and bailiff office, that Judge Newman had allowed more testimony in regarding the financials, and that also the defendant had decided that he may testify.
All right. And where were the jurors at the point that that conversation occurred?
There were a few jurors standing in line, and there were some in the bathroom, I'm sure, because they said they were waiting on jurors to get out of the bathroom. And there were some in the jury room just milling around from what I could see, looking down the hallway.
And again, what were the words that you said during that conversation? What were the effect of them?
To Mr. Bill,
Yeah. And what did you say?
I told him that that Judge Newman was allowing more of the financial evidence in, which would prolong the testimony in the trial a little bit, and also that the defendant had decided that he was going to testify.
Did you say anything about this being an important day? Pay attention. We'll get coffee for you. Things like that during that?
I usually give a little pep talk to the jurors. It's sometimes hard sitting a long time, but my usual, and I do remember saying, pay attention, it's a big day today. Whatever you need, let Mr. Bill know or one of the other bailiffs, and they'll be glad to get it for you.
Did your comments or were your comments in any way phrased in favor of one side or against another side? Or were they more of a neutral comment about paying attention?
No, it was not for one side or the other.
Were you present when the jury went to the Moselle property to conduct the jury view?
I was.
All right. And was Judge Newman there as well?
He was.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No, no.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there that bloom and smell good, or words to that effect?
I did.
All right. And was there any other conversation related that you had where you made any comment about the case or the merits or anything like that?
Oh, no, no.
During the course of this trial, did you have a bailiff employee whose primary job it was to see to the jury and their security and keep them separate from everyone else that was involved in this trial?
I did.
And who was that?
Mr. Bill Polk.
All right. And he was ultimately the jury coordinator in this particular case?
That's correct.
During the course of the deliberations, once the jury went back there, did you have any contact with the juries or have any substantive discussion with them?
Not at all.
Did you have any discussion with them about logistics, about staying in a hotel or anything like that?
I did not.
Did you have any interaction with the jurors or anything to do with them having smoke breaks or anything like that?
I did not.
During the course of the trial, did you have any discussion or interaction with the jurors about them giving any interviews to the media or making themselves available to the media? I'm asking during the course of the trial itself.
No, not during the course of the trial.
After the verdict had been reached and the case was in sentencing, did you have any conversation with any jurors at that time after they had already entered their verdict and been individually polled?
Yes, after the sentencing.
All right, and tell the court what that interaction was at that time.
There were several outlets, news outlets, that wanted to interview the jury as a whole and really wanted to get them up to New York. And so I was trying to get a hold of all the jurors to talk about that. That was something we had not prepared for.
Did you at all pressure the jurors to speak, or did you just tell them that it was their option to speak or not, and here's the contact information?
I did not pressure the jury to speak. No.
Did you advise them that it was their decision and their decision alone whether or not they wish to speak to the media?
It was totally their decision.
And did you advise them of that?
Yes, yes.
I'm asking again, but I just want to be sure. At any time, did you make any comment to any juror or in the presence of any juror in which you at all tried to influence them in favor of one side or against another?
I did not.
Did you understand, being a longtime court employee and clerk of court, that that is outside the boundaries of what is appropriate interactions with the jurors during the course of the trial?
Absolutely.
And at any time, did you violate that rule that you understood?
I did not.
Court's indulgence, 1 moment. Nothing further this time, Your Honor.
Please, of course, Your Honor.
Mr. Harpootlian, on cross-examination.
Here come the theatrics. I do think it was important.
We spent 6 weeks together, didn't we?
We did.
I'll mute.
And during those 6 weeks, you were as helpful to me as you could be, correct?
I was.
Accommodated just about every request I made.
Yes, sir.
Wait.
I do think it's in poor taste that she even reached out to the jurors. Just my opinion, even after the fact,
Where were we? Oh, yeah.
to do a publicity tour. I don't know.
Heard, that was the microphone that was supposed to, you're fine where you are, absolutely fine.
It's obscuring my ability to question a witness.
Yeah, well, what I'm wondering is whether you can be heard without a microphone.
Why is Murdaugh smirking?
Yeah, that would be good.
Okay, here's the thing. I do have to leave for a moment in about 5 minutes.
All right.
I will continue to leave this on.
I assume they can hear us.
I'll be able to comment, but I won't be able to.
Not as important as
Yeah, I agree.
Oh yeah, we're all friends. Right. We spent 6 weeks together in a very pressure-filled situation, correct?
It was a long 6 weeks.
It was a long 6 weeks. And during those 6 weeks, you were helpful to me in a number of different ways. Accommodating friends that I had that wanted to come watch the trial, for instance, correct?
That's correct.
You even allowed me to use the private restroom down on the first floor so I didn't have to stand in line with the rest of the people trying to get breaks, correct?
Correct.
So we have no animosity towards each other. You didn't do something to me and I didn't do something to you during that trial, right?
Absolutely.
Okay. Now, given that, I'm going to ask you some questions today that may indicate to you that I have some antagonism towards you. Let me disabuse you of that. I'm here doing a job representing my client, and you've been around the court system for decades, correct?
Yes, sir.
So you understand what we're doing here today.
Yes.
Now, let me understand a couple of things. I think, and I've read your book, some editions of your book. There's several. We got a bunch of emails in which you have drafts that you forwarded to your co-author, correct?
Correct.
Objection. I believe I would object to relevance. I believe any draft she sent to her co-author with the book is beyond the scope of this inquiry here today.
Overruled. You may proceed.
Thank you, Your Honor. And in those drafts, you say certain things about the trial, about the process, which you later did not include in the final version. It's called editing. Is that correct?
I would agree with that.
Okay. Now, let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
I'm so disorganized, I apologize. Did you seek assistance in this trial from other clerks of court?
Yes, sir, I did.
And who were they?
Rhonda McElveen, who is the Barnwell County Clerk of Court, and Renee Elvis from the Horry County Clerk of Court.
And were they there with you the entire 6 weeks?
No,
I mean, how long were they there? Or how often were they there?
Rhonda McElveen was there as often as she could be, probably several times a week. Renee Elvis helped me during the jury selection.
And did she begin, that is, Ms. McElveen, did she begin working with you prior to jury selection?
Can you repeat that question?
We began jury selection, I think, on January 23rd, correct?
Correct.
Was she working with you or consulting with you prior to the 23rd?
No, sir.
Did you have any conversation with her about the trial?
Not until she got to the trial on I can't remember the exact day she came.
Okay. Now, is she a friend of yours?
She was a friend, yes.
Was.
Well, she is a friend,
Okay.
yes.
She's done nothing to make you any less a friend.
No, sir.
Now, did you tell her about the time of the trial that you were going to write a book? That you had thought about and were going to write a book?
I can't remember exactly. I think we did have a conversation about a book possibly in the future.
And did you tell her you're going to write a book because you thought it would make a lot of money?
Oh, no, sir.
You never said that.
No, sir.
And did you tell her that you were going to write a book to make a bunch of money so you could buy a lake lot and build a house on it?
No, sir.
Okay. Now, did you ever tell her that you had given a juror a ride home, that you had accompanied Mr. Bill, what's his last name?
Bill Polk.
You're right. That you and he took a juror home one night? Did you tell her that? Did you take a juror home one night?
I didn't take a juror home one night.
Did
No,
Mr.
sir.
Polk and you take a juror home one night?
No, sir, we
Okay,
didn't.
you never gave a juror a ride in a car with Mr. Polk or without?
No, sir.
Okay. Now, also, during the trial, your daughter ended up on the Venari, is that right?
She did.
And she was coming up, and did you talk to me and Mr. Waters about putting her on the jury if at all possible?
I'm not sure that we wanted her to be on the jury if at all possible, but I think the question was, would she make a good juror? And I said she sure would.
Now, I don't think we asked you. I think you told us she would make a great juror. Did you not?
I remember you asking.
Okay. Okay. I was considering putting your daughter on the jury.
Yes, sir.
And who does she work for?
She works for Compass South.
Did she work for the sheriff's department at some point?
No, sir.
Okay. Did she work in law enforcement at all?
No, sir.
Okay. Now, let me ask you this. How many jury rooms were there?
We have 2 jury rooms in Colleton.
In this trial, how many jury rooms did you have? How many?
2.
Okay, so the entire jury wasn't together at any one time? They were separated into 2 rooms?
Yes.
Okay. And when they're separated into 2 jury rooms like that, are they next door to each other? Are they down the hall from each other? What-
They are next door to each other.
Okay, so, but if you close the door to one, can they hear what's going on in the other one?
Some women probably have very good hearing and men too, but I would say probably not.
Okay, are there restrooms in both of the jury's rooms?
There are.
Okay, are there two restrooms or just one?
There's one restroom in each jury room.
Okay, were either one of those restrooms designated men and women, or did everybody use the same one?
They were unisex.
They were unisex. Okay, now, prior to your testimony here today, have you met with the Attorney General's office in SLED?
I have.
On how many occasions?
I want to say twice.
Okay, and remember when the first time was?
I think the first time was in September.
Okay, and the second time was last week,
Yes, sir.
and that was in Walterboro?
Yes, right.
And y'all spent about 4.5 hours together?
I want to say maybe 2 hours together.
Okay. And in those 2 hours, you went over your testimony here today?
They asked me questions.
Did they ever correct your answers or suggest you answered differently?
Oh, no.
No.
Oh,
So
no.
you just went through what you went through in 20 minutes here. It took 2 hours to go through when you were with them.
There were times when I would step out of the room and come back in. But I would say we were there for about 2 hours.
Now, you have described in your book your role as Switzerland. Is that correct?
Correct.
Okay. And that is that you should not be in any way opinionated about what's going on in the trial. Is that correct?
That's true.
Okay. Yet in your book, you indicated a number of different points during the trial you had concluded he was guilty. Is that correct?
I think,
Your Honor, I object at this point. I don't know if her conclusions in the book are in any way relevant to what occurred during the trial and whether or not there was any communications with the jurors, which is the sole issue that we're here for today, is whether or not Ms. Hill had any extraneous influence on the jurors. And so I think this is going a little far afield. We object to the relevance, Your Honor.
Overruled. You may continue.
Let me give you an example. You indicate riding back from Moselle that you and 3 other people were in a car and you all decided adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
I can't remember if I put that in the book, but if you say I did, then I will
Did
agree
that
with
happen?
you. We did have a conversation about what each of us thought,
And all 4 agreed that he was guilty, correct?
and none of us were jurors.
No, trust me, I know that. But you had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter. One was our security officer, head security, and another was a deputy sheriff.
Okay. But the 4 of y'all rode out there, and based on what, and I mean, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene, that visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you, or you will concede that's what you wrote?
I will concede that's what I wrote, but if I may, I would say that a lot of that is poetic license in writing a book and in making it sound like that.
Okay, so some of it's poetic license, and some of it you just stole. You purloined it from that BBC writer, right?
Your Honor, again, I object to not only the relevance, but the scope of cross. I would object also under Rule 608. I don't believe that that's appropriate cross-examination.
Overruled. You may continue, Mr. Harper.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr.
so
Hartfield.
that's stealing, isn't it?
And it is, and for
Okay.
that, I'm very sorry, and I have apologized.
Okay. And that makes it okay?
What I did, and I
Okay.
apologized for
Okay.
that.
And part of the book is, you say, literary license, exaggeration?
I wouldn't call it exaggeration.
Okay. Now, let me ask you this. Is Switzerland and this is, you're saying this is happening while you're supposed to be Switzerland, you decided the defendant's guilty. And if Ms. McElmeen says that it's going to make you more money if he's found guilty, don't you think it's reasonable to assume that you may have crossed the line from time to time?
Your Honor, I object to the form of the question, assuming facts not in evidence.
Overruled.
Can you repeat that question one more time,
I'm
Mr.
not going to repeat
Hartwell?
it. Let me just move on to something else. Let me ask you, you had interactions with some jurors, and I believe in a conference in the judges' chambers, you indicated that you had seen a post on, is it Walterboro Word of Mouth?
Your Honor, again, I object. I think he's delving now into the Facebook inquiry. We believe, again, that that's irrelevant to the inquiry for Your Honor.
I will allow a limited, as I understand it, trying to impeach her testimony and explore her credibility. And I think I've already told Mr. Harpootlian that I don't want a whole trial about the business of Facebook and the egg juror, but I will allow limited examination on this point. You may proceed, Mr. Harpootlian.
Am I oversimplifying that? I mean, it's in your book. You saw something on Walterboro Word of Mouth, which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I oversimplifying that?
I remember reading one night something on Walterboro Word of Mouth. And when I was in the courtroom on a Monday morning, listening to the judge and the attorneys talking about a matter, it sounded like it was relevant to each other.
Okay. And you became aware somehow that this juror had a restraining order out for her ex-husband?
She told me that herself.
Okay. And tell me how it came for her to tell you about that. Where did she tell you?
She was very talkative. And when I was instructed by Judge Newman to go and get her from out of the jury room with a deputy following me, she was talking to me all the way back to the judge's chambers. And she mentioned that there were restraining orders out when they had divorced.
So how did the judge, who brought it to the judge's attention about this Walterboro Word of Mouth thing?
I let the judge know, thinking that it could be related,
Okay. And you let the judge know what?
that I had read something on Walterboro Word of Mouth.
Okay. And that you knew it was tied to that juror?
I didn't know that it was. I wasn't sure at all.
Who do you think it was tied to?
From what y'all were talking about at the bench, I felt like I needed to let him know, just in case it was related. There was something about an ex-husband and an ex-wife and somebody being on the jury.
You didn't tell the judge that you had found we call the apology post? You didn't tell the judge that?
I didn't call it that, no.
You don't remember producing it, saying that producing it to the judge, saying this is a post in which the guy that posted it on Friday night says the devil got in him and drinking and he apologized for what he posted? You didn't produce that?
My staff did, one of my staff.
But you gave that to the judge and gave it to us, did you not?
Yes, we did.
As if it were from that juror's ex-husband, correct?
Correct.
And you know it wasn't.
I don't know that, Mr. Hartpootlian. No.
So, and this, you did not take that juror out and talk to her before you took her to the judge? Is that your?
I never talked to that juror about stuff like that.
Okay. Did you ever talk to the forelady of the jury, separate from the jury?
I did.
Okay. And tell us, where did that occur?
When I would go into the jury room and I would speak with the forelady, we would be in like the hallway in the two jury rooms were side by side, and the opening to the jury room went out into the hallway, and we would be surrounded by the jurors at all times. Mr. Bill would be very, very nearby, or another bailiff as well, when we would speak.
And what did you speak to her about?
There were several instances. One was There was a juror who needed some feminine products. There was another time when Band-Aids were needed. There were times when Tylenol would be needed.
Other than items that were needed by the jury's health object, did you ever discuss, did she ever discuss with you if some issues jurors had emotionally or some issues with dissension in the jury room?
She only told me that there were some loud jurors and it made some of the other jurors a little upset. But other than that,
What did you tell her to do?
I told her if it got out of hand to write a note to the judge and that she could sign the note and get Mr. Bill to give it to the judge and the judge would handle that for her.
Okay. Now, you did publish a book after this trial, is that correct?
We did.
And you went to New York and took some of the jurors to the Today Show.
The Today Show did invite us, yes.
Now, one of those jurors that went up there with you, the day of the verdict, wore, for the first time I can remember, wore a suit to court. Do you remember that?
Your Honor, again, I would object to discussion of the jurors wearing a suit or a post-trial trip to the Today Show. And I don't believe there's any connection to the inquiry that's focused for Your Honor, and that is whether or not there was any extraneous influence during the course of the trial.
I'm going to connect it, Your Honor. I believe.
All right, overruled. You may continue, Mr. Hopper.
Did you text, email, or communicate on the morning before final arguments were completed that to people that this was on a Thursday, that they probably, if they're going to see the trial, should come on that Thursday because it'd be over by the next day? It would be, the jury would not be out very long. Did you ever communicate that? Email, text, or verbally?
I do remember saying that, yes.
And why did you think the jury would not be out very long? Had you communicated with jurors?
I had not communicated with jurors about anything related to this trial at all. I've been a court reporter for at least 14 years. I was clerk of court for 3. And you just get to where you kind of see things happen as they progress. And it's a guess, it's a gut feeling. And that's all that I meant by that.
Well, why are you telling this young man who wanted passes for the next day in an email, it won't be happening tomorrow? That was or did you say, you didn't say, I don't think, you just said, you better come today if you're coming. Remember doing that?
I don't remember that. But, if he wanted to come, I knew that the trial would be ending shortly as far as testimony. So if he wanted to come, he needed to come.
Why wouldn't the jury have been out a week on a 6-week trial?
They could have.
But
They could have.
you apparently were telling the press and others that there'd be a quick verdict. Were you not?
That was just a gut feeling that I had.
Okay.
And that was my opinion.
Your opinion, you were right. Jury was out 3 hours on a 6-week trial, correct?
That's true.
How much money did you make off that book?
There was not a whole lot of money made off of the book after paying different things and paying for some expenses that went along with that. But I want to say roughly around $100,000.
Okay. That's not a lot of money.
No, especially when you publish your own book
But that was $100,000 you made.
with my co-author.
Okay. In what period of time? 6 months?
I would say 6 months, yes.
When was the book published?
August 1st.
Okay. The trial was over. That's 6 months after the trial's over, you've published a book, correct?
Correct.
And then I believe you've recently stopped selling the book because of the plagiarism you've admitted to, correct?
Correct.
And so there's no more money?
Correct.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think is kindly what you put. Did you not?
Well, Mr. Hartpooley and my grandfather and Old Man Buster were very close.
Well, were they criminals?
I wouldn't know.
You wouldn't know, but you
I wouldn't
believed and you published that the Murdaugh family had run that part of the state and they'd been participated in criminal conduct, correct?
Your Honor, again, I would object to general testimony about the alleged criminality of this family. I'm not sure how that has any bearing on the focused inquiry before the court.
He's asking about what she said in the book. I'm going to allow it.
Yes, sir. Did you say that in the book, that they were criminals?
In the book, that was more of the literary ease that we take, I think, to make a story a little more interesting for the reader.
By calling people criminals? I guess what I'm saying is this. Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so you either made it up or you're lying about it? About the reputation of people that can't defend themselves? They're dead? You're going to call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for? Made it more readable, you said? Which
Liter-
sells books.
Literary ease. Yeah.
What?
Literary,
Literary what?
the literary ease that you can take when writing a book.
Literary ease you can take with writing a book. You can make stuff up. You can lie. You can lie about people.
Not with that. I think the public perception was one that it was very interesting during this time.
So you're feeding the monster out there that wants to believe bad things about the Murdaughs, and you'll make stuff up to do it. Let me give you another example. I read your book and I found this somewhat humorous. My co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that. What do you mean by neutering Jim Griffin?
Mr. Hartpoolian, it was a book.
Did you make it up? I know it was a book. The
Right.
Bible's a book.
Right.
Just because it's a book doesn't mean you can lie in it.
It's just a word that was
Argument,
used.
the nature of that exchange.
Don't argue with the witness, but the witness, Ms. Hill, you're instructed to answer his questions. You may proceed, Mr. Harpoon.
So let me get this straight. The book, and I'll see if I can cut to the chase on this. I could read you chapter after chapter, verse after verse, which is not true. Okay, not true based on my experience of being in a courtroom, and not true based on knowing some of the people you described. You say that is.
Mr. Harpoon.
I object. The counsel is just testifying right now as to his observations about the book.
Question, Mr. Harpoon, please.
You've conceded there are things in the book that you don't know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this whole scheme was about, selling books. As you told Rhonda McElveen, if him being found guilty would sell more books.
Your Honor,
Isn't that true?
I'd object to the argument of the nature of the question, the compound question, and assuming facts not
It is a compound question. If what you're asking is what she told Ms. McElveen, go on and ask that, but don't precede it with
Yes, Your Honor.
testimony.
Beg the court's indulgence for just a moment. Write your book about a juror whose ex-husband had posted something we now know probably wasn't her ex-husband. Did she have any other ex-husbands that you found out about?
I have no idea.
Well, you wrote We learned later the ex-spouses hadn't seen each other in 14 years and she had 3 restraining orders against him. Did she have 3 restraining orders against him?
I don't know. That's what she said.
Okay. Did you tell jurors at the end of the trial after President's Day break? President's Day break would have been a Monday, correct?
Correct.
But before Mr. Murdaugh testified, did you tell the jury not to be fooled by the evidence presented by Mr. Murdaugh's lawyers?
Mr. Harpootlian, I never talked to the jurors about any of the evidence
If the
in
answer
this
would be
case.
yes or no, then you can explain. Did you say that?
No,
Okay. Did you ever instruct the jury to watch him closely immediately before he testified, looking at his actions, looking at his movements? Did you ever tell a jury to do that?
no,
Did you ever tell the jury to pay attention to Mr. Murdaugh's testimony?
to pay attention, not specifically to his testimony. I did tell the jury to pay attention,
To what?
just generally in the hallway when I was speaking.
Not to him,
No,
just to any witness.
right.
Okay. Did you ever warn the jurors the defense is about to do their side? This is right before, right at the beginning of the defense case. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Did you ever tell the jury that?
No, sir.
Okay. Did you ever tell the jury, if you get emotional, we want to see your face because that is what they want to see? You ever tell them that?
No, sir.
Did you ever tell the jury that Mr. Murdaugh was about to testify?
I didn't tell the jurors that.
Now, did you tell the jury that if they didn't reach a verdict by 10 o'clock, they were going to have to spend the night?
No, sir, I did not.
Did you ever tell them they were going to have to spend the night at
No,
some
sir.
point? Did you ever tell them that they couldn't smoke?
No, sir.
Okay. You got any other books in the works?
No, sir.
I mean, doesn't this make a good book? Thank you.
Yes, sir.
Your Honor, there were a few matters that came up on cross, obviously, that I'd objected to.
You won't waive your, you may reserve your rights to object to the entire line of testimony, but you may offer cross-examination subject to the assertion of your objection about the testimony.
Thank you, Your Honor. One of the things you were asked about is finding this Facebook post, and you brought that to the court's attention after a different issue had already arisen related to a juror. Is that correct?
Correct.
All right. And are you technically capable of manufacturing a Facebook post? Is that anything that you have any capability to do?
I'm not.
All right. And did you ask your staff member to go see if she could find this post?
I did.
Did you tell her just generally what you recalled reviewing?
Yes.
And did you give her any further instruction other than that?
No.
Were you sitting behind her as she was doing this particular search or anything like that? Or did she eventually report back to you?
She is very, very techie. And then she reported back to me.
All right, so you weren't there when she was searching anything like that?
No,
She was like, I couldn't find that post, but I did find this, and handed you the Facebook post. Is that
Correct.
correct? And then
correct,
you provided that to Judge Newman, and ultimately it was provided to the parties. Is that
right,
correct?
correct.
You were asked about conversations that you had with the forelady. Did those involve logistical issues and things like that for the jury?
The conversations with the forelady was everything. There was nothing regarding the defendant and this trial.
All right, so they were logistical issues, not anything to do with the substance of the trial. Is that correct?
Absolutely, yes.
You were asked about whether or not you had texted some people, this won't be long. Was that at all in any way based on any conversation you had with a juror as to their internal thinking or anything like that? Or was that just your assessment being an experienced person in the court?
Absolutely not.
It was based on just your assessment?
Just my assessments, yes.
Did you ever communicate with the jurors on how long they would be, or did any juror ever tell you how long they thought they would be?
I never talked to any jurors about anything like that.
You were asked about your book, and I don't want to get into too much detail about that, but you were asked about some of the assertions that you made in the book. And you were asked if these were lies. Were they lies, or were they ultimately things that were based on inferences from newspapers and community stories?
You are leading by, this is your witness, Mr. Waters, so please ask a direct question.
Thank you. Some of the statements that you were asked about in your book, were they lies, or were they based on your inferences from just general community knowledge and things that you had researched and knew?
Still leading, but I'm not going to
All right.
Thank you.
He's
Mr.
right about that, Mr. Waters. Just ask a direct question.
Did you lie in your book?
No, I did not.
Thank you. You were asked about when you told the jury to pay attention. When you asked that question, did you also mention anything about we got coffee for you or things like that?
I knew that Mr. Bill would take care of that. And the jurors knew too. Coffee, we had done some Dunkin' Donut runs. We had provided coffee, different other things to help stay awake in the cold courtroom that we found ourselves in. And so I knew anything that they needed, Mr. Bill would see that they got, because that's what he did.
At any time, did you have any conversation with any juror in which you tried to influence their decision?
I did not have a conversation with any juror about anything related to this case.
Nothing further, Your Honor.
All right. Ms. Hill? I want you to turn your attention to a hearing that Judge Newman had about the alternate who was dismissed, sometimes called the egg juror. Do you recall that hearing?
Yes, ma'am.
In the hearing, Judge Newman expressed his unhappiness with you for questioning that juror before he questioned her. Do you recall that?
I do remember seeing that.
Well, then let's go back and talk about that juror. You on examination in this courtroom, you said that she talked about a lot of things to you, but you didn't ask her any questions. But that's not completely accurate, is it?
Yes, ma'am, that is true.
Well, you asked her direct questions, and that came out in the hearing that Judge Newman had. You asked her questions before she was even examined by the judge, did you not?
Your Honor, I did not ask her any questions.
the juror was examined by the judge in a hearing. Do you recall that hearing? It's the second hearing on this matter.
I do recall that hearing, yes.
And the court asked you about, the court asked this juror about postings on Facebook, did he not?
Correct.
And the juror said she gave Miss Becky my full access to my Facebook. And I put positive posts on it. I've done that for the past 3 years. Do you recall her testifying in that regard?
I do remember reading that.
And the judge said, has anyone posted anything on Facebook about you? And the juror answered, I was not aware of it until Miss Becky told me today. Do you recall that?
I do remember her saying that.
And do you recall the judge saying, what did she tell me? And the juror said, she asked me if I had an ex-husband, and I said, yeah. Did you ask her that?
I remember her saying this, Your Honor, but I did not ask her any of these questions.
And she further says, she asked me if I had talked to him about the case or being on jury duty, and I said no. I had questioned her about why she was asking me that. I haven't seen my husband since 2014. Do you recall her testifying to that?
I do remember that, yes.
And with that, having jarred your memory, do you recall asking her about her husband and his post?
Your Honor, I don't remember saying anything about that.
Well, what was the post that you read in the Walterboro Word of Mouth? What was the nature? You read that, did you not?
I did.
What did it say?
My memory is a little fuzzy with that, but it was about a ex-husband who found out that his ex-wife was on a jury, and he didn't think that she would be a good juror. And it just sounded very similar to what I had heard the judge and the attorneys speaking
So
about.
you then went to that juror and questioned her about that, did you not?
I did not, Your Honor.
Well, she says in this testimony that she didn't know about the Facebook until Miss Becky told me. Was that incorrect?
I'm not saying.
Some kind of conversation went between the two of her for her to know about that post, correct?
That's true. And I'm thinking that it could have been someone, it wasn't me. I just know that it's not me that she talked to about that.
Well, when the judge, the judge was questioning the juror about this, she also said that she had 3 restraining orders against him. And she also said, I was very upset after she told me that. Like I said, I have 3 restraining orders against him, and I wouldn't have anything to do with him if I didn't have a child with him. But I haven't seen him since 2014. Y'all didn't discuss that, the restraining orders?
On the way from the jury room to the back chambers where the judge was, she was very scared. She was talking about the 3 restraining orders that she had out on her husband at the time that they were divorcing. And she was scared that he would be trying to get back in contact with her again.
Well, how do you know that? Did she tell you that?
She was talking about that on the way to the jury room, to the chambers with the judge.
And in the court, in this hearing now that I'm looking at, that the court is conducting, she said, they're asking about this Facebook post, and she said, Miss Becky said she went to look for the post again and that it had been deleted. I don't know who she talked to or anything else, but she said apparently, do you recall her saying that?
I do remember her saying that.
And the court then said, what did she tell you about that? And the juror said, it was after you let us go on the last break. I was very upset. This is what you're talking about. And she came down and talked to me and said that apparently, I don't know who talked to him, but he said he was drunk and he removed the post. Do you recall that?
Well, she didn't tell me that, and I didn't talk with her about that.
Well, you saw that post, the so-called apology post, did you not?
Right, I did.
And you assumed that was a post from her husband, did you not?
Right.
And then you talked to the juror about that, did you not?
I did not talk with the juror about that.
Well, who did you talk to about it? Did you bring it to the judge's attention?
No, we didn't get a chance to talk to the judge about that.
The court asked this juror, has the clerk discussed anything about the case with anyone on the jury? The juror said, not that I'm aware of. The judge said, okay, she was just discussing with juror. She pulled me aside when we went downstairs after the last break. I want to say it was after lunch, and we came back, and that's when she first told me about it, about this, what we now know was not a post from her husband.
Right.
But you assumed it was a post at the time, and y'all had a conversation about it, correct? Don't that just nod, answer the question.
Yes, sir. Yes, ma'am. I believe that it was one of my staff that she talked to, but it was not me that she talked to.
But the juror says, and I want to say it was after lunch we came back, and that's when she first told me about it. She's talking about you.
Correct.
Then we went back into the court, and I never even got to sit on the jury. The judge says, the judge then stops the questioning and she exits the room. Mr. Griffin, Your Honor, I think that satisfies it. She hadn't talked to anybody, hadn't expressed an opinion, hadn't made up an opinion. She's got an ex-husband and she has 3 restraining orders against him. The court said, Mr. Waters, just obviously we're all invested in this. My main concern, I certainly would love to, but not love to, but want to hear, what one of these individuals said. But, she answered the questions as she did, talking about the juror. They then have a colloquy about this juror and whether this was really her husband that put this post in that you talked to her about and apparently talked to the court about at some point. Am I right?
That's right.
And then at the end, the judge said that he was not too happy with your having talked to the juror before you talked to him. Do you recall the judge saying that?
Yes, ma'am, I do.
And did you pop right up there and say what you're saying now, that you never talked to her?
We never talked about it after that. I wasn't in the room when he said that.
The judge brought up another thing right after sentencing that I want to explore with you briefly.
Okay.
One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And there were sealed exhibits presented in this case that were photographs of the 2 decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And those photographs were sealed by the judge, were they not?
Correct.
And when the testimony about them was completed, they were under your control as the clerk of court, were they not?
That's correct.
How was it that those photographs came into public view?
Are you talking about after the?
I'm talking about the fact he alluded to it on sentencing and said that he was frustrated about it and was going to try to look into it. Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits, and you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. J. Bender, and then we had the pool photographers and someone from maybe the state, I believe, or the Posting Courier, along with the court reporters, someone from court administration, and then someone from the clerk's office every night that would go over the exhibits to make sure everything was correct and within our domain.
Were any press people ever allowed to view the exhibits, even the sealed exhibits that you had on file?
No, ma'am. No, ma'am.
What was the methodology for allowing them to examine the exhibits? How'd you handle that?
I wasn't there a whole lot when we did this every night, but it's my understanding that the people that were involved with the exhibits, and especially the court reporters, and there was a certain time frame that they were allowed to take their pictures, and everything was all of the pictures were looked at by the court reporters that were there, and the lady from court administration, along with someone from my office and Mr. J. Bender, to make sure that everything was done correctly.
What I'm asking is how you handle having them, the press, view these exhibits.
If I remember correctly, the press, we had certain designated photographers, and then someone, I think, from the state or the Posting Courier, and they were responsible for putting it out on a stream for the rest of the media to
And would
access.
they do that by photographing the exhibits as they were in your possession after court was over that day?
That is correct.
All right. And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
And so you think that you're aware of the fact that some of these on the scene photographs of the two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am. Yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
All right. Finally, you have indicated about your book that some things that you put in there were, you called it literary license, not literally true, correct?
Correct.
Did you ever, by any kind of email communication or in any way, shape, or form, indicate or state that you wanted a guilty verdict because it would increase the sales of the book? Did you ever say that in an email or verbally or in any other way?
No, ma'am, I did not. It didn't matter to me if it was guilty, not guilty, or a mistrial.
Well, in your book, you suggest that the guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book. And part of that is because I think it was a guilty verdict.
Well, this is way that you were describing a time way before the verdict was rendered when you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you say your eyes met with jurors and others at Moselle, and y'all had an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent. But at no time did I read or try to read someone else's eyes. And that was just one of those gut feelings that I wrote in the book.
I feel like you can cut the tension with a knife. Like, I feel tension and I'm not even there. I bet that place is like crazy anxious.
You wrote in the book, speaking of a time before the jury verdict was rendered, I was conflicted about knowing the Murdaugh family and about having so many people watching and listening to me as I read the verdict. I was mostly concerned about Alex being found innocent when I knew in my heart he was guilty. I had this fear that the goodwill the Murdaughs had built up in the community would influence the jury. You wrote that, did you not?
Yes, ma'am.
So you had those feelings well before the verdict was announced in this case. You had some definite opinions and feelings about what the verdict should be, did you not?
I did have a certain way that I felt.
But
I would never-
that's not any poetic license, what was said there. That's how you felt, correct?
Correct.
All right. Those are
People
my
are allowed-
questions. Anything further from the state, Mr. Waters?
Oh, wait. I mean, people are allowed to have an opinion. Even jurors can have well,
Very
technically.
briefly,
they're not
Your
supposed to.
Yes, sir.
You were asked a number of questions about the interactions during the in-camera proceedings with the juror who was excluded. Were you in the room during the entirety of those interactions, or just were brought in here or there as those occurred?
No, I was only brought in for my asking of my questions from Judge Newman.
And you were asked a little bit about sealed exhibits and about Judge Newman's comments at sentencing at the end of trial. And just to clarify, those were not pictures of any sealed exhibits. It was a picture that someone had taken in the gallery that had actually been disclosed. And that's what Judge Newman was talking about, to your understanding?
That was my understanding. Yes.
And then after the trial, there was even a post-trial hearing or some discussion about the fact that some body cam videos had not been sealed, and Judge Newman fixed that problem after the trial. Is that correct?
Correct.
Nothing further, Your Honor.
Just a couple questions.
Mr. Harpootlian?
Let me understand this correctly. You would agree that you did release all of the exhibits in this case, sealed and unsealed, to the Texas film crew. Is that correct?
No, sir.
Hmm?
No, sir. I did not release the sealed exhibits.
What about to Netflix? Didn't you indicate to the judge they'd been mistakenly released and you're getting them back?
As an error before, when we realized everything, yes, those two did go, and Netflix had not even, they said they had not even looked at them.
Did you get them back?
We did get them back, yes.
And what about a Japanese film crew? Did they get exhibits, the sealed exhibits?
They did not get any sealed exhibits.
What about NBC Universal?
No sealed exhibits.
But you do concede that Netflix did get sealed exhibits.
They did it as an error. It wasn't
Who's
listed.
there?
Well, I would say the court reporter didn't mark it on the listing.
Well, why were you so accommodating to these national documentary folks? I mean, is this good for the book? I mean, the more documentaries out there about the Murdaugh thing, the better your book sales are. I mean, there was money in this for you, right? Again, it's about the money, right?
What's your question now?
Isn't it financially beneficial to you at the time to get more of these photographs out, more publicity, more Netflix, more HBOs, more Japanese? Doesn't that sell books for you? Didn't you see a financial advantage?
Not at all.
Not at all. Okay.
More
Thank you.
Japanese?
No further questions.
What?
You messed up down.
You messed up down.
Let's hang on for a moment. Mr. Lewis.
She's using her subpoena. I just wanted to make sure she's not.
Well, I wanted to step down. Yes, she's still under subpoena. I haven't heard what's going to be said. Mr. Harpootlian still has some things he wants to raise about other witnesses and so forth. So what I would prefer is that she remain with us until we see what else is going to happen. You may step down.
Obviously, those are her attorneys, Bamberg and I guess Lewis. Well, I think Bamberg is her attorney.
All right, Mr. Harpootlian.
And Bamberg represented some of the victims
Your
too.
Honor, we
Hakeem Pinckney,
literally
Mark.
millions of documents in this case. Ms. Miller just uncovered an email relevant to what you asked. We don't have it printed out. But what it is an email from Rebecca Hill to Miho Takachuchi, something.
Oh my God,
Miho,
please don't try.
first name. The Buford McDowell body cam should not have gone to you. Please get rid of it. Do not use it. The Judge Newman specifically ordered that body cam not be used if it got out. Apparently, it's still on the videos we were saved. I appreciate your attention. What about the other body cam video? We can see on many news documents. It seems the camera was on the other police personnel. I mean, here she's having emails between this Japanese production company about body cams telling them to get rid of it. I think that's important, and I can have a copy of this printed out for you when we can get it to a printer for the record.
That would be fine, but do you want to offer it as an exhibit?
I do.
All right, Mr. Waters?
I have no objection. If I could just ask the date of that.
The date is July 17th, 2023. July.
That's after the verdict.
All right, that's one thing. What else? I will admit it. I will allow it. That is a impeachment of her testimony to me that she did not send any emails
Yes, Your Honor.
or release anything.
Yes, Your Honor.
In fact, she changed that testimony on redirect when she said she did, so-called by accident, release some things.
That doesn't appear to be by accident. So we like that to be. Secondly, I have sitting outside the courtroom, the clerk of court for Barnwell County, Rhonda McElvey. She specifically denied saying certain things to the clerk of court of Barnwell County and denied doing certain things. I think you're going to find her testimony extraordinarily instructive and educational. And it shouldn't take. I would be shocked if it took 20 minutes.
Well, in light of the answers she gave to my questions and some of yours in that regard, I'm going to allow it. Now, I want to know what else we're looking at here.
Damn.
Do we have only one copy of this?
I don't think I've ever been as envious to be in the courtroom as I am now. I'm so annoyed. This is like, again, it was probably good because I'd be in the background going, oh.
I want to hand up to you an affidavit from a witness we would propose to provide in addition to clerk of court. This is a alternate juror, not the egg lady. This is the alternate juror who was dismissed when she was not needed for deliberations. And she is here also ready to testify. And I would expect her testimony would take about the same time as one of those jurors this morning.
Sir?
I would expect her testimony would take about as much time as one of those jurors this morning.
This is your offer in refutation of the testimony Ms. Hill has given today.
She denied saying any
She
of this.
denies saying anything. That's correct.
Yes, Your Honor.
Now, is this juror, alternate juror, going to testify?
She's here. Yes, Your Honor. She's sitting.
Well, you just say she's here. She's available.
Yes, ma'am.
All right, Mr. Waters.
Your Honor, a couple things on this particular alternate juror. We've just been handed this particular affidavit. Your Honor, I believe that Your Honor had correctly ruled that the focus again was on those jurors, and the inquiry has been made to those particular jurors. I don't know why we would go into detail with an alternate juror that ultimately did not sit in any deliberations and cannot testify as to any effect on the verdict, which is the ultimate inquiry before Your Honor. And so we would object to this particular testimony as far as it relates to the alternate juror.
Here's the one thing that gives me some heartburn, and you can help me with this, please. I stand by
Not
the ruling that I
heartburn.
have made that only jurors can be questioned about the effect on their verdict. And that is why I did not allow the testimony of the egg juror in that regard. He is now offering this testimony, and it's testimony of certain things that were said to the jurors as a whole, rather than just to this particular juror. And I would, as I say, I would ordinarily not allow this, but Ms. Hill testified several times during the course of her just concluded appearance that she never told any jurors anything along the lines of what has been asked here, particularly the comments about they're going to say things that will try to confuse you or throw you off, things of that nature. She was asked about that, and she denied she ever said anything like that. So this is an attempt to impeach as I see it. And that's what's giving me a little heartburn about just turning him down flat.
A couple things to add to that, Your Honor. First of all, I think that we have some very specific statements and a specific individual that's mentioned here. And so if we're looking at Rule 613 B, which is essentially where they're operating, I don't know that there was an appropriate foundation laid as to the specific time and to whom these specific statements were made. I think that it needed to be cleaner with regards to that, as to, you know, mentioning this particular person and as much as you can, the time and place and the very specific statements that were made. I think Mr. Harpootlian, again, we had these general allegations and kind of went through those, but I don't know that now that we've just been handed this affidavit, that they were set forth as an appropriate clarity that's required by 613B. So I think there's a failure there.
Mr. Waters, look for a minute at paragraph 3, 4, 5, 6. 7. Those paragraphs all address things that have been asked her, and they are pretty specific as to time and place. And the content of this testimony is an attempt to impeach her, Ms. Hill's testimony. That's why as I guess colloquially I said, I'm having a little heartburn about excluding this, is because she was asked directly about these matters. And this testimony would be in conflict with that, which would be permitted to impeach someone.
Right. And Your Honor, I certainly understand the point. I guess I would have just 2 points to that. Number one is that, as we've already talked about, this evidentiary hearing is within your discretion in the manner, particularly when you're talking about jurors and the manner to be conducting that. Now we're talking about putting the juror on the stand and having attorney examination. And I think under the case law, that's within your discretion as to how that inquiry should go, as opposed to were we purely in a trial setting and applying the evidentiary rules. But if we were applying the evidentiary rules, again, strictly applied, I think that I don't know that they have laid the foundation with enough clarity to offer extrinsic evidence under 613B. And that would be our argument there, that we just had generally discussion of some of these concepts, but not the place, time, and person to whom it was made with the specificity that 613B requires. So that would be our evidentiary objection in the event that Your Honor is addressing those. So that would be our position. I do also, before we get started, I do want to go back and address the sealed exhibits issue whenever it's appropriate.
Sure.
If now, I'm happy to go.
Mr. Harpootlian?
Your Honor,
Slow for a minute. I'm turning to Mr. Waters to try to get some clarity about why he objects to this testimony. One is the 613 issue that he's explored, and I understand that. He now wants to say something about the sealed exhibits. So I want to hear from him on that, and then you can reply to both of them.
I'm sorry, Your Honor.
That's all right.
Distracted by Mr. Barber.
Sure, I understand.
And, finally, going back to the juror issue, we would also raise 403 as well, just because of the nature of the inquiry that we're here to assess. Going back to the sealed exhibits, I just want to clarify for Your Honor, Mr. Griffin and Mr. Harpootlian were at this hearing. After the trial, there was a release of, and these were publicly filed exhibits, of a number of exhibits. What also got released at the time were 2 body cam exhibits, which had images of the victims at the scene. Those had inadvertently not been marked as sealed exhibits. And ultimately, then we had a hearing in front of Judge Newman, and essentially those were clawed back. And so I just want to be clear that when we're having testimony about that particular thing, as it relates to what Ms. Hill was saying, those were the sealed exhibits that were released. And again, at the time, they had not been marked sealed, and that was sort of retroactively fixed. And then the other issue, of course, is, Your Honor, is again that the issue that Judge Newman was talking about after sentencing was a gallery photo. It was not what apparently would be maybe a press photo of the exact exhibits. And what we did at trial, and Mr. Harpootlian can speak to this, and Mr. Bender could as well, is at the end of each day, first of all, the sealed exhibits would have a cover sheet or a folder that they would be in, and then they would verify with the parties that these are the okay exhibits, these are the sealed exhibits. And then at that point, after court was concluded, the media would then be allowed to review and or photograph or get copies of the unsealed exhibits. So that's just how the procedure was working at the trial.
That's very helpful to clarify this, because I now see this in perspective, that there were that the materials that were photographs at the scene or depictions at the scene of the two victims. What you're telling me is that those were inadvertently released after the trial by, I guess, it would have to be by the clerk of court. She's the one that had them, and then they weren't properly marked, and
That's
they
right.
were then clawed back.
Yeah, they were the two body cam videos, and so in those videos, it weren't physical images, but they were the body cam videos, and then in those videos, you could see the victims at the scene.
Right.
And those two exhibits, to my recollection, were the only two that should have been sealed, but they, in fairness, were not marked sealed, and that's how they got released. The second we realized it was a problem, we took care of it and clawed those back.
That clarifies that issue for me. So I frankly, that puts my mind at ease about what happened there. Now, Mr. Harputney, and I'll come to you momentarily. Anything else?
No, ma'am, Your
Okay,
Honor.
now, Mr. Harputney.
A couple of things I'd point out. The first is this: in terms of the statement by this alternate juror, she was interviewed by SWED on video, said exactly the same thing as she's saying in this affidavit weeks, if not months ago. So they know exactly what she said. I can assume they reviewed it. By the way, I asked, basically read from this affidavit as I cross-examined the court, and she denied each one of these statements. The second piece of that is this.
I know it's on that basis that I'm even pursuing the idea of you're offering something by way of impeachment. So I understand that.
And secondly, as to the sealed exhibits, I think we're going to hear testimony from Ms. McElveen that may elaborate on your concerns based on our interview with her this morning.
All right. Well, here's what we're going to do. It's about 3 minutes of 3, which is when I generally take my afternoon break. I'm going to adjourn the court or recess the court, and we come back at 3:15. And I will allow you to offer Ms. McElveen and the alternate. I want to make it clear that they will be offered on what we've talked about, matters about which Ms. Hill testified that you think are impeached by Ms. McElveen's testimony, and that you think are impeached by the alternate juror's testimony. So and the alternate juror's testimony, as I look at it, is the part about which impeachment would lie would begin at paragraph 3.
Yes, ma'am.
So do you understand what I'm saying?
Yes, ma'am. Can I make you one other offer?
Yes, sir.
Today and today only. Egg Lady is across the street.
Well,
No. If you want to put her on the stand.
No. I've made my position quite clear about that. I think we've got in the record what is needed in terms of what she says, Ms. Hill says, and what Ms. Hill says she says.
I agree. We did not intend on calling her. I just didn't want you to miss the opportunity if you wanted the opportunity to examine her.
Thank you, Mr. Harputney. All right, court will be in recess until 3:15.
Okay, I've got myself a little bit confused. That was probably his intention, I would have to say. I can't remember what email he, being Harputlian, referred to was dated July of 2023. In regards to even if it's well, technically, no matter which one it is, July was after the trial and after the verdict. The verdict was delivered in March of 2023. So I'm not sure how that has any bearing on the outcome of the verdict. I feel like Justice Toll is doing two things at once, killing two birds with one stone in the situation. I feel like she's interviewing Becky Hill to see if she did anything inappropriate. If Becky Hill is not guilty of being messy and doing things inappropriately, she's not being a really good witness to herself. From how Waters described the unsealed videos going to Netflix, sounded a lot more innocent, and although a really big mistake, still a mistake. They just weren't marked as sealed, which still sounds like that mistake falls on the clerk of court, but it sounds like it was an error. How Harpootlian presented it and how honestly Becky Hill was, how I heard her testimony, was making it seem like that just didn't happen at all. And then it turns out they have evidence that that did in fact happen. If it did or didn't happen, I don't think that's necessarily the issue. The issue is that she's impeaching herself on the stand. She's lying on the stand. I think that's the issue that Justice Toll is looking at. So still, if that was to a Japanese company, a film company that they were talking about, it was still July 14th. The trial was over. They had given their verdict. I don't get how either of those two things matter. And yes, I agree with Nikki. I don't think she should have a job. But that isn't why she's on the stand right now. That's not why she's testifying right now. She's testifying to see if she had any influence over the juror's verdict. What else do you say? The email Dick brought up was to the Japanese film company. Got it. And again, well, I guess she still impeached herself on the stand no matter what, right? Because she just testified to Harpootlian that she didn't reach out to the Japanese. So, and then he has proof that she does. If you just got caught lying on the stand, that doesn't really bode well for any of your testimony being believable. That proves that you're willing to lie, and you're willing to lie under oath, and you're willing to lie under oath as a clerk of court if it turns out that it is proven she lied on the stand. So, Lord. I really like Bamberg, which I believe again is one of her. I know at first Bamberg said that he was representing Hill, but now Justice Toll was just addressing someone named Lewis. So let me see real quick. Who is representing? Can I spell representing? Yeah, let's say maybe it's just another attorney that works with his office. I'm not really sure. According to the state, which is our South Carolina state paper, whatever, Justin Bamberg, known for representing various victims of Murdaugh's financial crimes, is representing Becky Hill. He's the son of 2 law enforcement officers, is also known for representing families of African American men who were shot by police in cases that received national attention. He's also one of our state representatives as well, I'm fairly certain. So yeah, I don't know if they work for the same office or not. I'm looking that up right now. Oh, except that's getting confused with the city of Bamberg. Bum, 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 bum. Let's see what other people are saying too while I'm doing this. Just same thing. Nikki's agreeing that it was. Let me go to his website. I want to find out who Lewis is. I'm not a jack-o'-lantern. My name is Lewis. Co-counsel. Let me see here. I'm going to stop this one for now and show you what I'm seeing. Does anyone know with StreamYard, can you show like multiple screens? Like I want to show multiple tabs that I have, but I feel like I have to exit out of one to show the other. And I find that annoying. All right. Oh, sorry. Pardon me. Okay. Here's paralegal. Hey, quit making weird noises, man. Paralegal. I mean, I'm glad that they're paralegals. I do not want to consult with anyone. I just want to see who's all about your office. Thank you. I don't know what. Okay, I don't really know. So there you go. I'm gonna take it off of this one. I don't see where Lewis, Jack-o'-lantern Lewis is. You haven't used StreamYard in forever, Nikki. You really should. And you should get back to streaming as well, because I said so. And although there were problems with previous people, I will have to say, yourself included, but the other person, who shall not be named, I'll just switch accents real quick to give you a clue. She did help me with stuff like that a lot, so you know. Okay. What the hell is melon? Listen, you know I don't know this stuff. Why are you doing this to me? I'm gonna stick with what I know. If it ain't broke, don't fix it, okay? I use StreamYard. I know there's something called Streamlab, but I use StreamYard because I got milkshakes. I'm such a dork. Okay. I feel like Harpootlian might have gone back to his like World War II days when he was yelling out the Japanese. I feel like the rest of this hearing is going to be even more unhinged. Yeah. So what I was saying before, I think that Justice Toll is kind of taking this opportunity, and I kind of don't think she's wrong for it, in questioning Hill on her behavior in general in the courthouse, especially in regards to this trial. She had said before at the conference, Justice Toll did, that, you know, we're not going to make this the trial of Becky Hill. Hold on, Bubba. Hold on one moment. My son is home. So if you hear him. Hi, Bubba. You can come in here if you want. I know. Yeah, said that she did not want to make this a trial of Becky Hill, but she's kind of questioned her like it is, you know. Justice Toll said specifically that this is just in regards to the statements that were made to the jurors to find out if they were made and if they were not made. And if they were made, did that have an effect on the jurors' verdict? As many have said, I find the timing of Juror Z coming forward and saying that her testimony influenced her verdict very questionable. I also find it a lot more shady that they were trying to get her to come back around and give some more testimony. Like, oh, and then some. I don't know. I don't feel like Becky Hill or Jersey are credible to themselves or to the people they're testifying about. Man, have I expressed that I'm so glad I wasn't a juror for this trial? I mean, I wouldn't have been. I don't live anywhere close to any of those counties. I don't live in that district, but I don't envy them. Number one, I would have excused the hell out of myself if I could and been like, no, I cannot be biased, which is true. I could not. I felt like he was guilty from the get-go. But the stress and the fear that they may have experienced during the trial, and the fear of, like, I don't know, being harassed or being watched, if they were or were not, for how they were taking in the testimony. Basically, were they getting outside pressure from the community, from other people, from attorneys? Were they? I don't know. To vote a certain way. And now, with this a year later, looking like it might go toward a retrial, I would not be happy. And I don't know if there's any way to have like a civil suit toward jurors that have had this information all along and are just now coming forward and continuing to change their testimonies, of it being sworn affidavit. Again, people lost wages, people lost time. There's so much of the state's funding that came to have this trial and have it go on for 6 freaking weeks. And just from again, an emotional standpoint, I cannot imagine having to be apart from my family on a daily basis for this, not being able to access my phone, the emotional toll that this has on having to be present for court every day, hear the testimony, experience these things, and you're not allowed to talk about it with anyone. No one. So they had to go home every day for 6 weeks and not be able to talk about it. Couldn't vent, couldn't rely on anyone, couldn't cry about it to anyone. Just cry alone in the closet or a bathroom. You're on your own until we reach a verdict. I know, again, I was gone for 3 days for jury duty, but we only had court heard testimony and that sort of thing for 2.5 daes. And the fact that I could not, Jesus Christ, talk to anybody about it, and that doesn't even compare to what these people had to go through. All right, I'm gonna mute again. You.
Please be seated.
I wonder how her heartburn is doing.
All right, Mr. Harpootlian, I believe it's you to present your witness.
Yes, ma'am.
Please be,
Rhonda McElveen.
Man. This is gonna be interesting. So this is the other clerk of court friend of Becky Hills. Right, Nikki? Same. Same.
You swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, that's what I'm here for.
Thank you. Please have a seat on the witness stand. State your full name for the record, and please spell your first and last name.
Rhonda McElveen, RHONDA MCELVEEN. I'm gonna make sure I'm gonna stay here. Yes, sir.
Say your name for the record, please, so I can make sure I can hear you.
Rhonda McElveen.
Your Honor, can you hear? Okay.
I can hear you great, Dick. I can hear you, but I would doubt that anybody posted
that
lawyers
better?
would hear you.
Is that better? No?
Is that thing on, Mr. Bailiff?
I think this is Mike for the other courtroom. This is Mike for the next door.
I don't want to get into the thing going.
Well, I can speak up.
haywire, man.
I'll just speak up. How about that? I have a big voice. I'll use it.
It's just not on at all, though.
No, it's all right.
Is it on?
Yes, ma'am.
Okay. All right, Mr. Harpootlian, you may proceed.
I'll speak a little louder if that helps. Say your name again for the record, please.
Rhonda McElveen,
And Ms. McElveen, what do you do for a living?
clerk of court and ROD for Barnwell County.
Clerk of court in what?
Register of Deeds, I have 2 titles.
2 titles. And is that an appointed or an elected position?
Elected.
So you're elected by the people of Barnwell County.
Yes, sir.
And how long have you been the clerk of court of Barnwell County?
This is my 16th year,
16 years. And
and I'm running again, sir.
you're up this year, 24 is,
Yes, sir.
all right. Don't think I'm allowed to plug that, but you have been the clerk for 16 years. You're up again this year. Now, do you know the clerk
don't.
of, well, back up for just a second. Do you hold any position with, is there a state organization of clerks of court?
Yes, sir. I'm actually the president of the South Carolina Clerks of Court and Register of Deeds.
Okay. And that means that of the 46, there are 46 of y'all, is that
Yes,
right?
sir. Yes, sir.
And you were elected to be the chairman of that group,
President of that group.
president of that group.
Yes, sir.
Now, are there certain rules
She's
and
a president, lady.
constraints that clerks should operate under in terms of dealing with juries?
Yes, sir.
And is there training for that, or is there a book for that, or how do you learn that?
You have the Clerk of Court manual for one that's on the judicial website. You also have the law books that have it in there. There's actually two separate forms, SCCA 237 and 238 maybe, that has regulations on it. And then we also have in the handbook or not handbook, but in the program within the CMS system, they actually have rules and stuff that you can go by as well.
Now, as a clerk of court, are part of your duties to deal with juries?
Yes, sir.
I mean, we understand there's a jury venire that's brought in at the beginning of a term, and then individual juries are picked for both civil and criminal cases. Is that correct?
That is correct, unless it's a non-jury trial.
And then there's just a judge, like we're doing here, right?
Yes, sir.
And in the process of picking juries, do you assist as clerk of court? When I say assist, who actually picks the jurors out of a hat, or whatever the process is?
Well, actually, the first process is you draw a jury by computers through the CMS system, and then summons are sent out. And then once we come to court, we usually do a roll call. We see what everybody's doing, what their jobs and everything, to help the attorneys to decide which jurors they would like to get. They have so many strikes, etc. And then you call the names, and they have the strikes, and then that's your jury pool.
And then the judge will seat a jury in a jury box, although I've never quite seen a jury box that looks like that, but a jury box in a courtroom, right?
That is correct.
Your jury box in Barnwell County is like 2 rows of 7 or 8 people.
Well, I actually have a jury box on both sides of the courtroom, because I have the grand jury on one side when they convene, and then I have the petit juries on the other side when they convene.
Okay. And the jury, they're sworn by the judge, and then they're put in the jury box, and they begin to hear arguments and testimony and jury charges by the judge. Is that correct?
Well, actually, sir, where we do it, the clerk of court usually swears them in with the judge presiding over the whole deal.
Okay. Once that jury is sworn in, what is your role in terms of dealing with those jurors individually or as a group? Are you allowed to talk to them individually, to pull them out, to converse with them about your opinion about the case?
To pull them out of the trial while we're going on?
Yes, ma'am.
No, sir, we're not. If they're on a break, et cetera, or if they request to see someone, then we manage to, I'll go in the door open. I'll say, which one of you needs to see someone? It might be the judge. And I said, hold on. And then I go get my judge. And so we've got a juror that needs to speak with you.
Do you converse with jurors about the merits of the case, by the merits, whether someone's guilty or innocent, or whether a plaintiff or a defendant should win in a civil case? Do you ever do that?
No, sir. About the only thing I ever do is go in and count them and tell them I can count up to 14 without even using my toes. And then I might get their lunch order. That's it. And the doors are usually open when I'm doing that.
And you have bailiffs that sit with the jury or sit outside the jury room?
They sit outside the jury room, and usually there's one beside them in the courtroom in case somebody needs something. But usually they'll catch my eye, or they'll catch the judge's eye, and we'll get something handled.
Okay. So did you have any contact with the clerk of court of Colleton County prior to her being elected the clerk of court of Colleton County? Did you know her before she was clerk of court?
No, I did not.
Did you come to know her once she was elected clerk of court?
Yes, I did.
And was it a pleasant relationship?
It was.
And how did you come to be, and to cut to the chase, you ended up being in the courtroom during the Murdaugh trial for part of those 6 weeks. Is that correct?
Yes, sir.
How did you come to be there?
When Becky and I met each other at a conference, clerk of courts conference, where she was discussing that she had that trial coming up, and I knew that she was relatively new, and I said, I'll offer to come help you if you would like. And I think she ended up talking to Judge Newman about it, and they both said, yes, it would be good that I was there.
Okay, because you tried a murder case or two in the past, correct?
Yes, sir.
Okay. And did you go and help Becky Hill try that murder case?
I did. I couldn't go for the first 3 days because I had court in Barnwell, and I told both of them if I had court going on in Barnwell, I could not be in Collin County.
Okay.
Did she look shocked when he asked her that question? Like, yes, I have been present for a murder trial. Like, he wasn't asking if you have done anything.
To your knowledge, had Ms. Hill ever been the clerk of court that managed a murder trial prior to this?
Not that I'm aware of, sir.
So this was her first murder trial, as far as you know?
As far as I know of this magnitude, I don't know if they had one before then or not.
Okay. Now, when did y'all, I mean, initially, what were you talking about in terms of logistics and how you did it and all those sorts of things?
Yes, sir.
During that, before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir.
And
She
did
wanted
she-
to write a book. Yes,
Wanted
sir.
to write a book. Did she indicate what the book was going to be about?
About the trial.
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis in reference to the book? What would help the book?
A guilty verdict.
And
That-
tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then further conversations, a guilty verdict would sell more books. And we left it at that. This was before, even in December.
And when did she ever say that again to you during the week she spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books.
That would be the best way to sell books, yes, sir.
The best way to sell. Now, during this process,
I have
did she ever
something to say
express
about
to you
that.
an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty. And she made a comment that guilty verdict would be better for the sale of books.
Okay. Now, as a result of a conversation you had sometime during the trial, I don't want you to relay to me what was told you. Did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Collin County and I was told that she had taken a juror home the night before. And I was in the courtroom and I saw her, and it was between the pews and where the back row pews are. And I mentioned to Miss Becky, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me. Mr. Bill was with me. I said, Becky, you don't do things like that. I thought we had stopped everything. It wasn't far enough along to really cause a major problem, or I would have told Judge Newman. But I thought we had to understand that you did not spend time alone with the jurors.
Okay. Now, I'm going to.
So this clerk
read
knew
you
that
some
and didn't say
statements.
anything.
Well, first of all, did you ever hear her say anything in front of you
Amazing.
to a juror about whether or not, on the merits of the case, that is, whether or not he was guilty or innocent, or what you should pay attention to? Did you ever hear her? What, if anything, did you ever hear her say to a juror or in the presence of a juror? Anything?
No, sir.
Okay. But let me ask you if you've ever heard her say these statements, and if so, to who? Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understand mean, do not be fooled by the evidence presented by Mr. Murdaugh's attorneys. You ever heard her say that?
Your Honor, this time I would object. This witness was specifically called as a Rule 16.3B extrinsic evidence. I think we've covered the two grounds that would be permissible for her to testify to, and I believe that should be the extent of her testimony. So we would object to any further extrinsic evidence as improper impeachment and also irrelevant. I think that the issues that were raised with the prior witness have been covered, and that was the express reason that this witness was called, and Your Honor allowed the testimony.
Overruled. You may continue.
Thank you. Did you ever hear her say that?
Can you repeat the verbiage?
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys.
Yes, I did.
And who was it said to?
It was said to me,
Okay.
and sometimes it might be a staff member in her office or someone from the media there. But other than that, I didn't hear her say it out there in front of any jurors.
Did she ever say to you or to other people around you, I'm not talking about jurors, watch him closely, talking about Mr. Murdaugh. This is just before he testified. Look at his actions. Look at his movements. Did you ever hear her say that?
Yes, sir.
Okay. Did you ever have any conversations with the bailiff, Mr. Bill?
Yes, sir.
Did he ever discuss with you the clerk's contact with jurors?
No, sir.
Okay. Did you ever hear her say that the defense is going to try to confuse the jurors? Did you ever hear her say that?
No, sir. I don't think so.
Okay. Now, let me deal with one last area. Let me see if I can simplify this. There was a setup in the courtroom. Pardon me, I got a little frog in my throat. And I'm fine, thank you.
I think I'll share my bottle over here if he wants part of it.
Once a cork, always a cork, Your Honor. So, and I was there, you were there, this judge was not there. And prosecution tables over here, defense tables over here, judges up here. And then there's a rail behind which the clerk was. And because of all the massive electronic equipment we had there with big screens, there was an area over on my right facing the judge. And then I think you were located in that area right between the judge and that area. Is that correct?
Talking about in the well area?
Yes, ma'am.
Okay, yes, sir. For the
Now,
most part, now sometimes I was out there with the screen
right,
in the gallery.
right. But there was a screen on which you could see not only what the gallery back there could see, but the images that only the jury was supposed to see that were under seal. Is that correct?
That is correct.
Now, there's a woman named Rhonda Ryder, correct?
Rich.
Rich. And tell me who she is.
At the time, we did not know who she was. The first time they were there, we didn't know. Then she came in Miss Becky's office the night before, and she asked if she could have another seat in the courtroom for the next day. And Miss Becky said yes. And she says, and what's your name again? And the only reason why I remember Rhonda, because of course my name being Rhonda. And the next day, Miss Rich was sitting, I don't know how to tell you, but she was sitting. Do you know where Doug was sitting?
Yes, ma'am.
All right. I know, Judge, you don't know where Doug was sitting, but anyhow.
But Doug was the audiovisual guy, and he had access to the unscreened, the unsealed images, correct?
Yes, sir.
And she was sitting right next to him, right?
Yes, sir.
Okay.
In that little part. And
So she could see the body cam, she could see the unredacted corpse pictures, the autopsy pictures, all the photos that the judge had sealed, correct?
well, no, the only thing she could see was what was being put up at the time.
Right. But
Okay.
as they were put up, she could see them.
Right. But they tried their best to seal it where you couldn't, but you could still see it there. I didn't see any of the photos. Okay.
But she could see them.
Right. And Doug was really having a problem with that. And I can also tell you that our court reporters didn't know who she was either. Okay.
And she turns out to be a writer, correct?
Yes, sir. After I found out. Yes, sir.
And her name is Rhonda Rich.
Correct.
She was given access to areas that only court personnel should have had access
Right, but then we broke, and then she moved her in the well with me. She was about on my left, and either Elizabeth or Mike was on my right. And I noticed she was taking notes. And I asked her what was she doing, taking notes. She says, I'm a Sunday school teacher. Well, I immediately covered up everything I had.
to. You don't
And,
trust Sunday school teachers?
So,
You don't trust Sunday school teachers?
let me just, there's too many preachers in my family on both sides, okay?
This
So,
was just a character. I'm
You
sorry.
determined she was not a Sunday school teacher, and later learned that she was a writer writing about the Murdaugh case, correct?
Now, I don't know if she's ever a Sunday school teacher or not. There's just, I don't even know where she goes to church or anything, so I can't tell you that answer. But I did find out that she was a writer because shortly after she was put there, and evidently after I covered everything up, shortly after that, Judge Newman asked for a recess so we could find where people were going to be working. And that's when she put Miss Rich out in the gallery in control of that screen.
And she ended up writing the foreword to Becky's book. Is that correct?
Yes, sir.
Okay. And Becky gave her access to area only court personnel should have had. Is that correct?
That is true. But now I'll be honest with you, sir. There's been a couple times when we had other people that were sitting on that side. We weren't planning on seeing sealed documents that day,
Right.
but there were some other people that sat there, but nobody that actually sat in the well that wasn't court people.
Okay. Thank you, court's indulgence.
Mr. Waters, on cross-examination.
Did he just clap?
Oh, okay.
Sasha, stop it. My dog's
Judge, do
whining.
you have an extra bottle of water up there by any chance you're willing to share? Oh, Miss Elizabeth's got one. Thank you.
Ms. Buckley, how you doing today?
I'm good, sir. Please call me Rhonda.
I always called you Miss Rhonda. I've known you for a long time as well. In fact,
Yes, sir.
I tried one of those murder cases in front of you years ago. It didn't right.
Yes, sir.
Wanted to ask a couple things. I won't be that long. One of the things that you said earlier is you said when you initially were talking to Miss Hill, she said something like, we ought to write a book or something.
That is correct.
Okay. And so did y'all have any further discussion about you writing the book or participating with the book?
Oh,
or anything
no,
like
sir.
that?
I'm crazy enough not to write one.
Okay. During the course of after the trial, she did send you like chapters and things like that to take a look at.
I did get to see a couple of drafts of the manual.
Okay, so she did send you those to take a look at and review and that sort of thing. Is
Correct.
that correct? Okay. All right. And you were asked and again, Your Honor, just to be clear, I'd made some objections.
You do not waive any objections by cross-examination. They are all preserved.
Thank
You
you.
may proceed.
Thank you. You mentioned, some statements that you attributed to Miss Hill, during the course of conversations during the course of the trial. Is that correct? Just things like watching closely, watch his mannerisms, things like that. And where were those conversations? Were those conversations taking place back in the clerk's offices with clerk staff and people like that?
Yes, sir. In the clerk's office. It might have been downstairs in the bathroom.
Okay.
That some of us had privilege to go to.
All right. So you and Miss Becky and other court staff, maybe just discussing the case and that sort of thing. Is that correct?
That is correct.
And people were expressing their opinions about what was going on and that sort of thing. Is that correct?
Now, when we were having those discussions, there weren't more than one or two, maybe three people there.
Okay. But just a few people there just talking back behind the scenes. That's what I'm driving
Correct.
at.
Yes, sir.
It was behind the scenes, and it's not uncommon for, clerk staff behind the scenes, not to the parties, not to the litigants, not to the jurors, but among themselves back in the hallways back there to talk about the day's activities and things like that. Is that fair?
That's correct.
Okay. And that's a big difference between the natural conversations that people that work together, court staff and the like, have with each other and actually having those conversations in front of the jurors, right? There's a big difference between those two, correct?
Yes, sir.
Okay. And it's not uncommon for you. You're a clerk of court. You got people that work for you. Y'all are going to have private conversations about what's going on that are not to be shared, particularly with jurors, but with the public as well. Is that fair?
That
to
is
say?
true.
Okay. All right. And so there were conversations like that going on that you were privy to and part of. Is that correct?
That is correct.
Okay. All right. And You mentioned a little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens, private conversations with court staff behind closed doors. But you never once saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right. And if that had happened, if you had observed anything untoward or improper going on at this particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
And you never did that because you never observed anything like that. Is that correct?
That is correct.
Okay. All right. Now, you were asked a little bit about Rhonda Rich, who was a member of the media, and how she was placed kind of back where the defense IT guy was. Is that
No.
correct?
I didn't say she was part of the media, sir.
Okay. Well, she was a writer.
Yes, sir.
Okay. All right. And then you said that that eventually, though, Judge Newman stepped in, and then she was moved out into the gallery in charge of the screen out there. Is that
Right, but I don't know. I thought Miss Becky moved. I'm not saying Judge Newman did.
Okay. All right. And over there in that area of the, if we look in the courtroom, there was sort of the grand jury box over here, and that was where court TV was and media was stationed and that sort of thing. Is that correct?
That is correct.
All right. And inevitably, there were media members that could view some of the images that were being shown. They were just not able to report those just because of the nature of where the courtroom was. Is that accurate?
Well, I was told they couldn't see it, so I don't know what they actually saw because I didn't discuss it with the media.
All right. You never had a conversation with court TV or anything like that.
Other than the fact that be careful what they put on my front page of the New York Times on me.
All right. All right. And you're not aware of any image or confidential information or sealed image or anything like that was ever made privy to Miss Rich that was put in any sort of publication or anything like that. Is that correct?
None I'm aware of, sir.
Okay. Because if you had found out about that too, you would have immediately gone and reported that to Judge Newman because you would have said, that's improper. That I need to go report to
That
the
is
judge, correct?
Correct.
And you never once saw anything during the entire course of this trial that caused you to say, you know what, I got to go talk to Judge Newman. Something ain't right about what's going on here. Is that correct?
That is correct.
And you would have done that without a doubt if you had seen that, correct?
Yes, sir.
All right. Now, in looking at, back at this trial, you mentioned that there was a few days at the beginning of trial that you weren't there because you had your own court to take care of back in Barnwell County, correct?
Correct.
All right. And then pretty much after that, I guess you were pretty much present the majority of the remainder of the time. Is that fair to say?
I was. I had one medical procedure done. I missed 2 days, but basically other than that, I was there every day.
All right. And there was a period of time, though, during the middle of the trial where Miss Becky had a medical issue and had to be absent from the courtroom for about a week or something like that.
That is correct.
Okay. And during that period of time, you were present and functioning as the lead clerk of court during that period of time.
That is correct.
All right. So the reality is that you were present for probably as much, if not more than anyone in the clerk's function during the course of this trial. Is that fair?
Yes, sir.
Okay. And again, just to reiterate, there was not one time that you observed or came in possession of any information that you were like, I got to go talk to Judge Newman about this.
No, sir.
Court's indulgent. 1 moment.
Man, I don't know why he didn't say it. Like, you didn't see anything that you deemed worthy of reporting to Judge Newman. So obviously you didn't see or hear.
Very good, Mr. Harper.
Like, why didn't you report
Yes, sir.
on driving the juror home?
Mr. Waters indicated to you that you were not aware of whether or not, and you agreed that you never witnessed her talking to a juror about the evidence. Is that correct?
Is that lady back there in a neck brace or really
Do
extraordinary?
you know,
dress back?
but she did admit to you that she had been with a juror alone in a car for some period of time when you confronted her with that. Is that correct?
No, she's a
Yes, sir.
turtle.
And did she indicate to you what she talked to that juror about while they're alone in the car?
No, sir. She told me, the only thing she told me was that she did not discuss the case that she had Mr. Bill, the bailiff, with her, and he could tell her that, tell
Okay.
that.
And when she said she didn't discuss the case, did you bring that up or did she bring that up?
She brought that up.
You didn't say shouldn't be with him because it's frowned upon?
I did tell her that I would caution her on doing that because the perception of dealing with the jurors one-on-one is not tolerated.
Is not tolerated. Thank you.
Then why didn't you report her
Thank
to
you,
Judge
Ms.
Newman?
Hackett. You may be excused.
Why are you just saying it now? And being that you're president, clerk of
All right,
court,
Mr. Harper, let me call your next witness.
Your
Don't
Honor,
you have
we
a
call juror
duty to do
741.
so?
I know you're not going. Well, that's right. She's an alternate. That's all right.
Do we get to see the egg lady?
I got you.
And Your Honor, while she's coming, my understanding is I believe it's 4 questions.
Yes, sir. I have a copy, and I have given the court reporter a copy of this affidavit with the name obscured and the number, I think, as well. So, but the affidavit
Oh,
supports
I
this
thought we got to
testimony
see
that
her
you're about to
since she was
offer is
dismissed.
Court's Exhibit 5.
Dun dun dun. Maybe not.
Background about her getting picked for the jury and how long she's on the jury and
That's
if she's
fine.
excused. That's all we intend on asking these 4
All
questions.
right, sir.
Unless Mr. Waters asks.
Sure. I mean, they'll have
And
cross-examination.
I'll be crossing, so
He
I'm
will
sorry.
definitely open the door.
That,
so
all right.
he's limited to the 4 questions initially, is that?
Yeah.
No, sir. He's just telling me that's what he intends to do. Sometimes you can hold lawyers to that and sometimes you can't, Mr. Miller.
Yes, ma'am.
I intend on only asking her those 4 questions.
That's fine.
I intend on only asking her
Yeah.
those 4 questions.
Yeah.
Where are you, egg lady? I thought you were across the street. Where'd you go? Do you have your eggs? Where'd you go?
I'll talk with the lawyer.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth,
Interesting.
and nothing but the truth, so help you God? Thank you. Please stand.
Your Honor, I assume the same rules apply to her that apply to the other jurors in terms of her image appearance.
That's correct. There'll be no photograph made of
Too
this
late.
particular witness who was an alternate juror in the matter.
Too late.
Thank you.
We saw her.
I'm
Court
gonna
TV
refer to
effed
you
up.
as juror 741. It's what we got to do here, so we don't use your name, so people don't know who you are. Is that okay
Just
with
call her
you?
egg lady. We've already seen her face.
And
It's too
you and
late.
I have met before.
Sucks for her.
I came to your home one Sunday afternoon. I believe you're cooking Sunday dinner, and we talked. Is that correct?
Correct,
And then you were interviewed by SWED,
correct,
and you gave them a recorded statement. And then this morning you came here and you gave me an affidavit that you signed, and you're here with your lawyer. Is that correct?
correct.
Now, just for purposes of the record, you were a juror. You were selected to be a juror on the State versus Alec Murdaugh murder charge, correct?
Correct,
And you sat in the courtroom for 6 weeks and listened to all the testimony.
correct,
And you were the alternate.
correct.
And so when the jury went out to deliberate, you were excused. Is that correct? Now, I'm going to go through a series of questions based on your affidavit, okay,
Okay,
which you signed this morning, which was based on our initial interview with you and your interview with SWED. This is basically the same thing you told SWED. Is that correct?
correct,
In your affidavit, you say before the defense put up their case,
Lady.
Sir?
Lady.
Overruled. Go ahead.
Thank you. In your affidavit, you said before the defense put up their case, Ms. Hill told the jurors, quote, "The defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off," unquote. Is this true? Did Ms. Hill
Accurate.
say
That's
that?
exactly what she told us.
I'm sorry?
That's exactly what she told us.
Okay. The next thing you say is Ms. Hill made the above statement warning the defense would try to confuse us in the presence of all the jurors as we assembled in the same jury room. Is that correct?
Correct.
Now, y'all were initially in two
We was
jury.
in two separate rooms, and when she came in, we all went in one room.
Okay. Paragraph number 5, Ms. Hill said, "If you get emotional, we want to see your face because that is what they want to see." What does that mean?
She said, "Don't get nervous. Don't be afraid to show your emotions because that's what they want to see."
Who wants to see?
I don't know who she was speaking of. I'm assuming the court.
Okay. And then number 6, Ms. Hill also informed us Alex Murdaugh was going to testify, but I don't recall exactly what she said. All the jurors were assembled in one room when she made that comment.
Exactly.
She told you that Alex Murdaugh was going to testify.
Exactly.
Did you know before that he was going to testify?
I think we knew that he was going to come up. I think he was supposed to do it the day before, but he didn't. And I knew he was going to be the last person that afternoon.
Okay. During the visit to Moselle, juror number 826 and I walked to the scene together. Then juror 826 began walking with the clerk of court, Becky Hill. I could tell they were talking. I could not hear what was said between them. Is that correct?
Correct.
Is what you put in this affidavit truthful?
Yes, sir.
And this is what you told us back in
I don't remember that
August,
months
I
ago.
believe. I think I interrupted you cooking Sunday dinner.
Right.
All right, thank you. Please answer any questions defense may have for you.
Mr. Waters, or Mr. Meadows.
Thank you, May please, Your Honor. Good afternoon, Ms.
Good
741.
afternoon.
It's nice to see you again.
Yeah.
I think it's the first time you talked to Mr. Harpootlian or Mr. Griffin or any other attorney.
I can't tell you exactly. It's been months. It's probably been September, August. It's been months.
Okay. And were they the first attorney to talk to you, or was there somebody else that talked to you prior to them? Any other attorney?
No, I think he was the first person I talked to.
You sure?
I think it was so many people trying to call me, and I was trying not to be involved, so I can't quite remember. But he was the first person I seen.
First person in person?
Yes.
Okay. So when he came to your house,
Yes.
Mr. Harpootlian came to your house?
Yes.
And at that point, was Miss Holly with him? Holly, do you mind raising your hand? You see Miss Holly?
Yes.
Okay. And was anybody else with him?
Yes. He was.
Mr. Griffin?
Mr. Griffin.
Thank you. And you gave them a statement then, right?
Right.
And did they record you? I mean, were they audio or video recording you? Did they say we'd like to record this?
No.
They didn't.
But neither did the people that came out. They didn't. I didn't know I was being recorded by them neither.
I'm not trying to fuss.
Oh, okay.
But is there an audio recording of your conversation with them that you know of?
No.
Did they say?
Not that I know of. No.
Okay. So you don't remember them saying?
No audio recording. We're required to tell her if we're recording her under rules. We didn't record her.
He's on cross-examination.
Thank you, Ron. And at that point, and that was again, do you remember, you said you think, was that around the end of August, 1st of September when they first came and talked to you? Roughly.
Roughly. I don't want to.
And you told them basically everything that you've told us now, right?
Yes.
Exact same thing.
Exact same thing that I told them.
Nothing less, nothing more.
Yes.
Okay. So Mr. Harpootlian, just, and you didn't sign an affidavit back in September or when you talked to him the first time?
No.
And why not?
Because he was just coming out to talk to me. He just was asking questions. It wasn't nothing officially. He had, so.
When you say nothing officially, I don't know what you mean.
He didn't, he was just coming out to ask, he was just asking questions about what went on during the trial. It wasn't,
But did they ask you to sign an affidavit that day?
no,
Okay. Did they ask you to sign an affidavit anytime right after that?
no,
No, they never asked you to sign an affidavit until this week?
no. I was supposed to meet with them a couple of occasions, but I was having my own personal issues and I couldn't come.
Okay. Well, I'm sorry about that.
No problem.
So you told them at this first meeting, back at the end of August, 1st of September, that y'all going to hear some things that will throw you off. Don't let it distract you or mislead you. Is that what you said?
That's what, I didn't say that. That's what the clerk of court told
Yeah,
me.
I'm saying that's what
Oh,
you
yeah.
said to them. I'm
Mhm.
sorry. Okay. And where did that take place?
She would always stand like on the outside of the jury room, like in between, like on the outside. She would never really come inside the jury room.
So there were two rooms, right?
Yeah,
Okay. One room and then the other room separated, correct?
right.
And you couldn't hear people talk in the other room, could you?
No, that's why when she came, everybody came in one room.
Okay. So this comment you said she made, did she bring everybody out in the hallway?
Some people was in the hall. That's why I said she was standing right at the head of the door.
Standing at the head of the door.
Right.
Was Mr. Bill there? Your bailiff?
Yeah, he would be standing in the hallway.
He's all out there, right?
Right.
And then she said in front of everybody, the defense is about to do their side. They're going to say things that will confuse you. Don't let them confuse you or convince you or throw you off. She said that to everybody.
She said that to everybody.
So everybody could have heard.
Everybody could hear it.
And you said you were all in the same jury room.
Yeah, we would all be in the same. When she came, she was standing in front of the door with the jury room that I was in, and everybody would come over. They would let us know before she came, they'll let us know like after lunch she gonna come talk to y'all, and we all would gather together.
So would you go from the two rooms into one room?
Some would be standing out. She was standing in front of the door. Some would be standing around her outside the door, and some would be in the room. But it was clear enough for us to hear and see her.
And Mr. Harpootlian led you, and Ms. Hill made the above statement warning that the defense would try to confuse us in the presence of all of the jurors as we had assembled in the same jury room.
We was all in the same jury room. She would be on outside the door, and we would be in the room, and someone would be standing beside her. We was always all together when she came.
And do you think that was unusual?
No, because I guess she didn't want to walk back and forth to room to room.
No, in fact of what she said. Do you think that was unusual?
Yeah, I did.
And if you get emotional and see his face, they want people to see your face?
Because some of the jurors was getting emotional, and I guess she noticed it, so she commented on it.
And you said you didn't, the statement he read, she informed you that the defendant was going to testify, but don't recall exactly what was said.
After,
When was that?
That was, I think he came in that afternoon, like at 2:33. So that was before he testified, I think.
And where was it?
Oh, in the jury room, where we were all, like I said, we would all meet.
And I guess what I'm saying is you're in two different rooms for a while, right? And y'all get up there, you split, don't you?
Yeah.
The people that talk loud in one room and the others in the other one? Pretty much.
No, it's not like that. It was just, they just split it off. They just asked us what room we wanted to go to.
So when you were fixing to come back to the jury room, to the box, you tell us you'd all go into one jury room together?
Only when she came to speak to us.
And Mr. Harpootlian asked you about, I believe, number 7 on the affidavit. And when did you sign this affidavit?
This morning.
And when's the last time you had talked to Mr. Harpootlian?
No, I haven't talked to him since he came to my house.
Or any of them before today?
No, I haven't talked to him since he came to my house.
She just signed the affidavit this morning.
Today, since then?
No, he was talking to my lawyer,
Okay, and who was that?
Sean Wilson.
Okay, and when had Sean Wilson talked to you?
He's been my lawyer
Since when?
since 2021.
Okay, when Mr. Wilson talked to you about this case and what you told Mr. Harpootlian prior to,
All right. they apparently don't object to this, but I am very uncomfortable with your asking what her lawyer told her.
And I wasn't going to contest. I was just looking for timing.
Well, she's told you a couple of times that he was her lawyer since 2021.
Well, see, you're a lawyer for this.
For what you mean for this?
Well, like being a juror.
For being a juror?
Yes, ma'am.
I didn't have he was always my lawyer.
You didn't hire him for this.
No, I didn't hire him for this.
But he had talked to Mr. Harpootlian about your affidavit and your testimony today, hadn't he? Is that a yes?
Yes, he was looking over the paperwork. He was looking out for me because he's my attorney.
When was he looking over the paperwork?
Oh, I guess ever since September, October, I wasn't really keeping up with it to be honest, because
So do you know if he's talked to Mr. Harpootlian this week?
yeah, he talked to him today.
Talked to him today?
We was together.
Who was together?
Me and my lawyer.
And Mr. Harpootlian?
Yes, when I went to go sign the affidavit
Okay. Where'd you sign it?
at his office,
At whose office?
Mr. Harpoot's office.
Your Honor.
I was supposed to.
I would object.
Okay.
This meandering, I mean, there's no jury here. It's you. And I don't know what this is.
How about helping a little bit? I think we got all the information. Yeah, all right. I think he's gonna move on. Yeah.
And that's the last question Mr. Harpootlian asked you about this affidavit, isn't it?
What was the last question?
During the visit to Moselle jury, say the number, whatever the letter is, it doesn't matter. You saw a juror, and I walked the scene together, then the juror began talking with the clerk of court. I could tell they were talking, but I couldn't hear what they were said between them. That's
Correct.
the last question he asked, right?
Correct.
So, and you have no idea what that conversation was about? do you?
No, I don't.
Now, the next, number 8, he didn't ask you about was I also overheard discussions in the jury room that Mr. Hill drove a juror home. I believe it was a juror whose nickname was Boston. Now, he didn't ask you that a minute ago, did he?
No, but
Just
okay.
yes.
No.
And you didn't include that in the first conversation you had with him back in August and September in this affidavit Miss Holly did you? You didn't tell him about that.
I can't remember.
Have you seen the affidavit Miss Holly did for you back in September 1st,
Objection, Your Honor.
2022?
Miss Holly did not do an affidavit. Miss Holly
She
did
just
her affidavit, her notes of what this young lady said to her, and what she included and didn't include was based on what Miss Holly thought was relevant at the time, but she can't be cross-examined.
That's not in evidence, Mr. Meadows, so I think you need
We'd
to
offer
move.
it, Your Honor.
Sir,
I'd offer it. Just to.
well, how is this thing gonna be authenticated?
You know, even more importantly, he said, he can't question her. I'm sorry.
Several people can't talk at one time. I don't even have the affidavit. Let me see what you're talking. You talking about the one that was just offered today?
This is one Holly did when he first talked to her back in August, and she's referred back to.
Miss Miller. Okay, Miss Miller.
This is Ms. Miller's affidavit about what she thinks this juror said.
Yes.
I'm not going to allow this, Mr. Miller. I don't see a whole lot of difference between this and what's been said in the affidavit that has been offered by Mr. Waters, but I'm not going to allow that.
Okay, thank you. You did not tell them about hearing that Miss Hill had driven a juror home back when you met with them in September, did you?
I can't remember.
Of course, I'm sorry. All right. Who is Boston?
She was a juror on the trial. I don't know.
Hey,
but that was
Wicca
the name.
Pickle!
I don't know her first name.
And what, if anything, did you know or convey about Boston?
She was a juror on the case, just like everybody else.
Anything else?
Nothing.
Ma'am?
No.
So again, Mr. Harpootlian didn't ask you, but when you, in the affidavit of today,
Mhm.
I also overheard discussions in the jury room that Miss Hill drove a juror home. I believe it was a juror whose nickname was Boston. Is that something was added after your lawyer was with Mr. Harpootlian today?
I don't know if I added. We talked about it today, but I don't know if I mentioned it in September or not.
That's
But
the
I
first
know
time
it-
you've ever talked about it, wasn't it?
Your Honor.
No, it's
There's
not.
no
Reason
reason
to raise objection.
The first thing is, Mr. Meadows, I'm going to caution you one more time about this. You cannot talk over a witness. The second thing is, you don't need to be marching all back around here. You talking only to me, not jury or anything else. So let's slow down and, this is repetitive of questions that have been asked before. If you want to take this tone with her, I don't know exactly what you're trying to accomplish.
I'm not trying to take Tony. I apologize. She knows that, and I'm sorry.
Well, you're just talking to me.
I'm sorry.
This is not some drama thing for the jury.
I know, I'm sorry.
All right, well,
I'm sorry.
let's
It
finish
does-
this thing up.
The only reason I did it, what he hadn't asked about it, and it to me is the key issue here. They're trying to say was different.
Mr. Meadows, I mean, you lecturing to the witness or to me or what? Please don't do that. Strike that from the record, please.
Don't strike. I'm
Let's
so
line
sorry.
it-
I'm
Let's
sorry.
line this up.
I
All right.
Ooh, people are getting in trouble.
In number 9 in the affidavit, that before the jury began deliberating, I heard a member of the court staff say the deliberation shouldn't take long. I don't remember specifically who made it, but it was made in the presence of the entire jury right after closing arguments in the jury room.
Correct.
Then I think you said something, Judge Newman came to see you afterwards, but after the jury went to their room, you were in a separate.
No. When we first left out the courtroom, we all went in the same jury room, and then they separated me.
Miss Simpson, when I mean to raise my voice.
Oh, that's
You know,
okay.
I apologize.
That's fine.
But when they started deliberating, were you in a separate room?
Yeah, when they started deliberating.
So you had no involvement in the deliberations or verdict of Richard Alexander Murdaugh? at
No,
all,
sir.
did you?
No, sir.
You didn't get to come back to the verdict, did you?
No, sir.
Have you read Miss Hill's book?
No.
Okay. And I noticed your interview. I did watch it. And I think Mr. Radford back there, you can raise your hand, Kyle Radford,
Mhm.
I think came to your place and interviewed you.
Right.
At some point during the trial, I think there was some discussion that somebody might have wanted to do an interview with you.
Yeah, that's what she said.
Okay. And then after the trial, I think there was some discussion, somebody, since you weren't on the jury, they may not have wanted to interview you. You remember that, roughly telling the officer that?
Yeah, that's not what she said. She came to me, roughly in the middle of the trial, and she said, I have a few people who would like to interview. She said, she didn't say a few. She said, I have a lot of people that's inquiring to interview with you. She said, but I'll have to get with you after the trial. But after the trial, she came back in the jury room and she started handing out cards. And she handed everybody cards but me. And she was like, I don't have any cards for you for an interview because no one wants to speak with you. That's what was said.
And did, I mean, you weren't happy with that, were you?
Yes, I was.
You were happy with
I don't need to be interviewed.
Stay course, go. Should get a lot to your delight, I'm sure.
Briefly, Your Honor. Meadows just asked you a series of questions that I'm not sure I'd heard before. Who approached you during the trial and indicated the media would want to interview you?
Miss Hill.
Miss Hill?
Miss Hill herself.
Just you or all the jurors?
They had, I think it's the day they had the bomb threat. And I think that was the day. And she approached me,
You,
by myself.
by yourself. And where were you?
That's the day in the lunchroom when they had the bomb threat. We went to the middle school. I believe that was the day.
The middle school. And she came over to you and said what?
That she had some reporters that was reaching out to her that wanted to speak with me.
To you?
Yeah.
Not the whole jury, to you. Was there anybody with you at that time?
No. It was
Did
just
she indicate why they wanted to speak with you? Just you?
No.
Did she indicate what reporters?
No.
And did she ever talk to you about doing interviews with the media after that?
No.
But you indicated she brought some cards at some point?
She brought cards in to hand to the jurors.
Before?
After the verdict was read.
Cards of media people?
Yes, sir.
Did she tell you she was writing a book?
No.
Did she indicate to you why it might be good for her if you did media interviews?
No.
But she had a conversation with you in the lunchroom of the middle school.
I believe it was the lunchroom. I think the day of the bomb threat. But I'm 100% sure she came to me and she told me that in the middle of the trial.
Was there a bailiff with her or just
No,
her?
it was just her.
Pulled you over and said, "Hey, I can make you famous. I can put you on TV."
She said she had media that wanted to talk to me.
No family members are there. It doesn't, not on the Murdaugh side. Stephen Smith's mom was there earlier.
All right, no further questions?
I'm not really sure why, but.
Very good. Thank you very much, ma'am. You are excused. All right, Mr. Hawkwoodman, is that it?
I need to put one matter on the record, Your Honor, and that is it.
All right.
What to put on the record.
All right.
Your Honor, earlier today, you received a very short affidavit from Juror Z. We'd like to proffer that and make it part of the record.
Right, I did not admit it, but I'll accept a written proffer, and if you would give the thing to me, I saw it on the screen on my law clerk's computer, but I don't have a printed out copy.
We don't either, but would you allow us to do that?
Well, I will allow, before I close the record with Ms. Harris, if you can get it to us. When can you get it to us?
We could email it this afternoon.
Very well. How about do this? How about email it to Mr. Waters, to me?
Stephen, did you just get off the
Ms.
witness
Diaz,
stand?
and
Is
to
that you,
Ms.
Stephen?
Harris, report.
So
And I
the
will
egg
send
lady
that
actually
it was
just
offered as a
testified.
proffer, and I will receive it as a proffer. I have not
And
admitted
Becky
anything.
Hill's clerk of court
All right.
friend, Rhonda something, she also testified.
Your Honor, we referred to earlier on a email to the Japanese television folks. I do have copies of that. I'd like to make that part of the record.
All right, but hand it up to me and let me see it.
We weren't
And
supposed to be
also
live
put
streaming
Mr.
this,
Waters.
Stephen. So Pickle, oh gosh, it's my feed. Come on. Again, you may hear a couple little squeals. For those that don't know, my son is disabled and he's nonverbal, so he vocalizes, but he's behind me playing right now. So I don't apologize for him. That's what you hear. He is currently going through boxes and destroying my stuff because that's what he likes to do in his spare time. Right, Bubba? You like to make a mess. But so the clerk of court friend testified that Becky did state she wanted to write a book. She also stated that She had a discussion with Becky
The
about,
hearing before Judge Newman to seal the body cam videos was on May 26, 2023. This email is in July, just to give you the context of
All
what's
right,
going
and
on.
this is being offered as a after the fact email to Rebecca Hill and her replies garnered from the emails that were released by Cotton County at a certain point. And it addresses the issue I raised with Ms. Hill relative to the security of sealed records.
Exactly, Your
All
Honor.
right, I'll admit it. Mr. Waters?
As to this specific exhibit, Your Honor?
Yeah.
Your Honor, I mean, we don't have any objection other than the ones we've raised just generally to the testimony. But I have no further objection to.
Very
Your
good.
Honor.
All right.
Your Honor, that's all we would have.
All right, hang on. All right, have you got a copy of it there? I got it. This is his next exhibit.
ew, there's little folks in the background. Ugh. So the clerk of court, Rhonda, testified that she asked Miss Hill, have you, actually she said, please don't tell me you took a juror home. And she testified that Miss Hill said,
Closing, you prepared? Very good. Mr. Waters.
all right, I'm a mute.
Thank you, Your Honor. Just to go back and reiterate as to the standard. And ultimately, we've of course argued that the defendant has the burden. We've also discussed that the standard for Your Honor, of course, is first of all, was there any misconduct that occurred? And then regardless of that, whether or not there was any effect on the verdict. And the standard has been expressed in multiple cases is whether the verdict is solely the product of honest deliberation or the product of outside influence. And that inquiry fundamentally, as the court recognized from the very beginning, focuses on the jurors themselves, because it doesn't necessarily matter what was said as much or what was intended or what was inadvertent, even assuming that those existed. What matters is what the jurors heard, what they perceived, and whether or not it had any sort of effect on the verdict. And Your Honor went through that inquiry with these jurors. 11 of those jurors were clear and unequivocal that there was no effect on their verdict, and also clear and unequivocal that nothing was said that could in any way be inferred as any sort of attempt to influence them. And I think that's very important, Your Honor, because, there can be sometimes behind the doors, as we've talked about, I think some of the cases recognize this, that some conversations can go on and things like that can happen. But ultimately, and while I think there were some cases cited in some of the various South Carolina decisions, that's unrealistic and not surprising to think that sometimes things like that can happen, an untoward comment or something was said. But that was an Aldrich, Your Honor, in the 1999 Supreme Court case. But the mere fact that something like that may be stated, that could be stated in a neutral reason, is not enough to undermine the verdict, because the inquiry ultimately boils down to what was it that those jurors heard, and in the end, though, did they listen to the instructions from the trial judge? Did they come to a fair and honest verdict? And Your Honor, the evidence here is overwhelming, I would say, from the people that matter, and that's those jurors. And that is, there was no effect on the jurors. And you saw every single one of them very clearly and strongly looked you in the eye, all 11 at least, and I'll get to the 12th one in a second, but looked you in the eye and said, no, that didn't happen. No, I didn't hear anything like that. No, there was no effect on our verdict. No, this was our verdict, and it was based solely, which was Your Honor's question, solely on the evidence and the law and the testimony at trial. And I think that carries the day. We have the one juror, and I want to make sure, because I'm about to say the number and I don't want to do that. Let me go back to Juror Z. And let's look at Juror Z and what she said, because Juror Z also said that, yes, I said this was my verdict. I was polled and said this was my verdict. Juror C also said that my verdict was solely based on the evidence and the law of the testimony at trial. Answered question number 2, yes. Absolutely yes. But then goes on after that to say she heard some communications from the clerk and then says, well, it had an effect on my verdict. Even after she had already answered question number 2, when she said her verdict was based solely on the evidence and the law and the testimony at trial. And beyond that, then, Your Honor, I think that it's very telling that the affidavit that was submitted from this particular juror, and we've been pointing this out from the beginning because it's very crucial and very telling, because despite the things that she alleges that happened, even though the other jurors say it didn't, despite the things that she alleges that happened, she says that she voted guilty because she felt pressure from other jurors. Not that her verdict was in any way affected from some supposed external influence. In that affidavit that was filed with the defense motion from day one, that is what she says, that she felt pressure from other jurors. And Your Honor, we've cited the cases over and over again that the internal mechanics of the jury room, the fact that one juror feels pressured by others, as long as there's not violence or things that go beyond the pale, that is not a basis for undermining a verdict. That is part of the deliberative process, and it's expected, and it occurs. But I think it's very telling that we have those conflicting answers. And Your Honor, without waiving any objection to the latest affidavit that we were just discussing from this juror, I think that's very telling, because now we have answer number 3 as it relates to this particular juror. And of course, it is clearly manufactured and rehabilitated, recognized after the fact. She, of course, this juror is represented by Joe McCullough. And ultimately, we've got now a third version of events from this very juror. So we have this juror who's given answers all over the place that are inconsistent with 11 other jurors who were very strong and unequivocal that, yes, this was our verdict. It was based solely on the evidence, the law, and the testimony, that there were no communications from Becky Hill that influenced that verdict. And I think ultimately when you look at the case law, in the end, it's up to Your Honor to make that ultimate determination and looking at all that law together. We cited a number of decisions, including, as we discussed, the questions to be had. I sent an email where we set out some questions that it's not uncommon, perhaps, for a juror to have a second thought. But the law is very clear that it does not recognize that, because what that would do would be to consistently and constantly put every verdict that occurs in any courtroom in this state or in the nation at risk. Jurors don't have to vote in perpetuity. They vote on one day and one day only. And here, Your Honor, the evidence is overwhelming that those jurors' verdict was the product of honest deliberation. And the only bit of contrary evidence to that effect is from a juror who, frankly, not only said that it was purely the result of honest deliberation, but then has answers all over the place. And Your Honor, I would say that the other 11 jurors are credible. They were strong. They were clear with Your Honor. And I think that ultimately that carries the day. Now, we've had testimony from other people since the jurors were here. We've had testimony, obviously, from Ms. Hill. We've had testimony from Ms. Rhonda. And we've had testimony from this alternate juror. But again, none of that testimony at all goes to what is the ultimate test for Your Honor, and that is whether or not this verdict was the product of honest deliberation. And on that, again, the evidence is overwhelming and strong and clear that it was the product of honest deliberation. It's very interesting as we look at some of the testimony from the other witnesses. And obviously we have Miss Becky, and as Your Honor has pointed out, we're not here to go through some of the issues that have been alleged or are percolating out there. That's not the point of this proceeding here today. But Miss Becky is a court reporter and then became a clerk, and was clear to you that she never made any comment in an attempt to sway the jury one way or the other. We have Miss Rhonda. And Miss Rhonda came in and testified, but I would submit to your honor that this is kind of a red herring, because what Miss Rhonda described were conversations that she herself admitted are just the kind of conversations that go on. And that's the reality of it. The conversations that go on among a trial team when we're not in open court, where we're discussing things, the kind of conversations that go on among court staff behind the doors, those types of conversations go on. But that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly, and understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And she was very clear. And I probably was as repetitive as anyone here today in asking that question over and over again, because I didn't want that point to be lost, that Miss Rhonda said, I was there more than anyone else, and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, something's not right about this. This needs to be fixed. Something's going on that's improper. And I think that that is an extremely crucial fact, because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened. When we look at the balance of those facts, when we have the clerk of court come in and testify that, yeah, maybe I did this, or maybe I did that, maybe I plagiarized the book, a portion of it, maybe I did this, maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry. But she was clear that she did not have any attempt to influence that jury. She was clear about that. And Miss Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? The defense, I think in one of their letters, tried to say that Miss Becky was the state's star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict. This was the product of honest deliberation, we would be the first ones here standing here to say that. But what we do know, Your Honor, is that what Miss Becky said and ultimately what Miss Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Miss Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Miss Becky and Miss Rhonda do is corroborate who are the most important witnesses. And that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced. Nobody tried to influence. And regardless, it was the product of our honest deliberation. And you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And I'm not saying that that person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box Every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously. They were not here to reward friends or punish enemies. They were here to do their job appropriately and fairly. You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair. Your Honor, we would submit that the motion for new trial be denied.
Mr. Harpootlian.
I still think they should have the juror
All right.
that they said was driven home by Becky and the bailiff. I don't understand why that wasn't part of this hearing.
Okay, if I stand here, Your Honor. That way I won't be interrupted by Mr. Harpootlian as I'm trying to make my points. Your Honor, I want to first start with State v. Green because I understand that that's the guidance. That's what we're following here. And reading, excerpts from State v. Green, first, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says, in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But the question is it prejudicial? Not whether the verdict would have been different. It is it prejudicial? And I'll keep reading. The court says we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different? It was their prejudice. Was this tainted process? Was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communications? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial. The court goes on to say, our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by bailiff to a juror rises to the level of constitutional error. Goes on to say the attempted bribery of the jury in Rimmer conduct, which goes to the heart of the merits of the case, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice in every case. And Your Honor, I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption, that we do get the Rimmer presumption if we have proven these comments were made. But I'm going to argue that we prove prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath that they heard Ms. Hill make comments about the case, whether it's, how they categorize it as merits or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that defendants don't normally testify. That's what Juror X said on Friday. Today, so that's one. who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says Ms. Hill said to watch his actions, to watch him closely, and then she said there are other things that he said I don't remember, and then we were allowed to show her, and with Your Honor, I asked her questions about her affidavit, and she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this, quote, this shouldn't take us long, close quote, and that if we deliberated past 11 p.m., that we'd be taken to a hotel. Those statements go to the merits. Those statements go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's two deliberating jurors down. The third deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case? And he says, yes. She said the day that Alex was taking the stand, excuse me, Juror P is a he, but he is saying that she, Ms. Hill, said the day that Alex was taking the stand, that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alex Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible. There's no way to credit her statements that she did not make these statements about his testimony. I mean, she crossed herself up as Your Honor is questioning her about the transcript involving the egg lady and how the egg lady learned that there's some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Ms. Hill told her. And that pretty much came out there. I mean, so, you know, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I mean, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard and the 4th alternate heard. That Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you got to put Ms. McElveen's testimony in our category. And Ms. Hill gets up there and says, never drove a juror home. Ms. McElveen's got no dog in this fight. And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. And Ms. Hill says, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. I mean, it's totally inconsistent. And for her to say, I never made these statements, you know, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, Yes. Then you ask how. And juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes. And so that's prejudice, Your Honor. That is prejudice from one of the 12 deliberating jurors. Was your verdict influenced by what Ms. Hill said? And good grief, how could it not be? How could it not be? And to ask all these other jurors who heard the same thing, was it influenced? It is really an impossible task, because you don't know what's influencing a jury, and frankly, that's why the Rimmer presumption is there. But let's try to sort this out. And Your Honor, I think it was a State v. Kelly case where the deputies went out and they were investigating the jurors' beliefs on the death penalty, and there was really no testimony about did that affect your verdict, but it was just so wrong. The conduct was so wrongful that the Supreme Court says that's prejudicial, and we're granting a new trial. I mean, this is prejudice, and this has been proven. I mean, Ms. Hill is not credible. Ms. Hill is not credible. And she's talking about her book, talking about taking a literary license to lie. Literary license to lie is that's what she thinks a literary license is. So her testimony should not be credited. We have proven, we have met our burden of proving that there was extraneous contact with these jurors. 3 of the 12 deliberating jurors have testified to that. 1 of the 12 says it influenced my verdict. How is that not prejudice? And that's all we have to prove. We believe, for the record, there is a presumption of prejudice that they have to overcome, but we have proven prejudice. And Your Honor, we respectfully request that a new trial should be granted based on the record developed today. Thank you.
All right. The arguments are closed. I will take until 5 of the hour to examine my notes, and then I will come and make a ruling from the bench on this matter. Court will be at ease.
One little second. Let me set something else up and I'll be right back. Talk amongst yourselves. I'm coming right back. 1 minute. Thank you. All right. I put this in here earlier. No. Copy this. If anybody wants to come up here and chatty chat, feel free. Just don't show a wiener or anything like that. It's too early for that. I don't like him. But it's okay, Bubba. It's okay. That really doesn't seem like an issue, Stephen. Hopefully you're not complaining. That seems like a win. Especially with your debacle in court earlier with watching the live stream of court TV. I mean, hello. Seems like a win. I feel like, based on everything that was given and talked about today, the testimonies given, the testimony today, I feel it would be unwise not to give a new trial. But I don't know, unless the judge is like very, very clear on why not, because my brain's a little bit scrambled. They brought up so many things that I didn't think the judge was going to discuss or allow today. I thought it was just simply the juror's testimony on whether or not Ms. Hill said anything to them specifically about the trial, and if she did that influence their verdict? And a lot more was brought in. So I'm kind of confused why she kind of allowed more than she originally stated at the conference. I know she explained a little bit of it today, but it definitely did seem like she was changing her mind a little bit, which, hey, you're a justice, I guess you're allowed to do. I see you, Pickle, 1 second. But because all of that was allowed today, I feel like it seems way too messy, and just as a South Carolinian, I would want to have a new trial knowing that all of that went on. Just personally myself. Hey, Pickle, how are you?
Hey, this is
Yeah,
just,
Nikki,
it's crazy to me. The way I'm looking at it is this, and I believe in justice, and I believe everyone deserves a fair shot, but the man has multiple other lawsuits and cases going on.
Sure.
He has caused the voters of that county, if not the whole state, I mean, hundreds of thousands of dollars, plus all the money he stole from people.
Mm-hmm.
And like I said in chat, for me, it's okay. If a few things were said, I do understand. But if only one juror is saying this would have influenced me, you can't negate the fact that all of the media leading up to there's like, and I know they weren't like OJ sequestered, right? But they were still sequestered to a point. Right.
Right.
So they were still seeing things at home, even though they say, oh, I won't look, but they do. We all know that.
I mean, I didn't when I was a juror, so. But
I mean, I wouldn't like. Right.
And it was only 3 days.
Right. And see, this is my thing. Like, I have a husband at home. He's my best friend. We talk about everything. I would talk to him about it. So I would already be breaking the rules. It happens. Pillow talk is a thing.
It happens. I literally did not. I just want to go on public record saying I literally did not. The only thing I told him was I may be a while today whenever it was time for when we were told that they were going to do closing arguments that day. And that's the only thing I ever said to him, other than I got picked for jury duty.
I did a mock jury for an insurance trial. And I mean, I think everybody pretty well knows, like, I'm very like take charge type A personality. And I had my mind made up immediately after. So when we went into deliberation, I kind of like, what did she say? I might talk to my hubby about it accidentally since I talk in my sleep. True, she does talk in her sleep. She absolutely does.
You can be responsible for that.
She's hilarious. I was on a voice with her the other day and a couple others. She was there, she was there, she was there, and she got silent for like an hour and a half, but was still in the call. And I was like, oh, Nikki fell asleep. I said something and she piped right up and started talking again. And I was like, where did you come
Really?
from? Yeah, it was great.
Nice.
But yeah, when I did the mock trial, they were like, well, who wants to volunteer to be lead juror? And I was like, I'll do it because nobody else wanted to. And I was very happy to.
Yeah.
And all of them had a different opinion than I did. And I swayed the whole jury easy enough. I literally was like, watch me, Joe, to my husband, because he was like, ugh. And I swayed them all. I basically got, like, when it came down for numbers, as far as like restitution, there was a little push and pull on that. But the number
Yeah.
came up dramatically from what everybody else wanted to like what I wanted. So if I said 5 million and they were all saying like 500,000, I think we got up to like 2.5 million.
Gotcha.
So I don't think, I mean, if you're asking a jury to be subjective and they, at the time of test or at the being read, my phone's ringing.
No problem.
Can you hear me, JC?
Yeah, I can hear you.
Okay, my phone's ringing. I have to answer it because it's the oncologist. I'll
Okay,
be
no
right back.
problem. All right. Yeah, I hear what she's saying. I'm a very big rule follower, and I would not, if someone told me I could not, well, I mean, if somebody said we couldn't discuss it, I didn't discuss it. Said we couldn't, I mean, there were several times when I was a juror where there was like this one witness who came in and she had a crazy 80s hairstyle. And I just wanted to comment on it so bad because, you know, sometimes I can be unkind. And I was like, nope, had to have some self-control there. Had nothing to do with what was going on for the trial itself and the testimony and the matter at hand. But on more than one occasion, our judge said you cannot even discuss what anybody was wearing that day, if they were smacking their gum too loud, nothing. So, yeah, I didn't discuss it with anybody, which was really annoying. And maybe that's why I'm so mad at this whole thing. And if the things Becky is being accused of saying turns out to be true, I mean, I don't see how it can't be. There was one juror who did testify that she said it, but that they weren't influenced by her saying it. So, I'm mad that a clerk of court, if these things did happen, if she did say these things, I'm so infuriated that someone in her position said and did those things. Again, rather than what is being discussed on whether she said something, didn't, the book deal, the photos, everything like that. Oh, and the photos. But if it's true that she drove home a juror, whether or not the bailiff was there, I don't believe that should have happened. That's just, I think there should be a new trial because of that. That's inappropriate, improper. No, I don't think there's any security cameras. And then when Creighton Waters was cross-examining the other clerk of court, Rhonda, it seemed to me that he was trying to bring up the fact that when there was a week that Becky wasn't there and Rhonda was, so who was in charge of the sealed photos and videos then? So everything that they're accusing Becky of doing in regard to the photos, could that not have been another person? I feel like there's way too much gray area in the logistics of what happened. So not everything in regard to the who's in charge of the sealed documents, sealed whatever. Feel like there were other cooks in the kitchen in regard to that. I don't think that alone should determine whether or not he gets another trial. One, because a lot of those happened after the trial. So it could not have had any influence on jurors' testimony. I mean, it's impossible. The comments about pay attention, be looking for what they're doing. To me, it seems like the clerk, if those things were said, maybe kind of took it upon herself to have more of the judge's position in giving jurors those instructions. That's what a judge says to the jurors when the jurors are in the jury box and it's on record and it's in front of everyone. And normally that's said at the beginning of trial. Kind of a introduction to what the expectations are going to be. Like, this is what you're allowed to base your verdict on. This is what you're not allowed to base your verdict on. You're allowed to base your verdict on what you feel your interpretation of the witness testimony is. You are allowed to do that. That is the point. You're supposed to base it on evidence and testimony. And evidence is also what the attorneys present and how they present it. I would be Stephen, or maybe juror, maybe not. I would be miffed that my local officials were looking like that. Yeah, well, that's... Yeah. You know, it's the South. It's South Carolina. And I just think certain people got a little too excited for the positions that they were in. And like, oh, I'm big time. I'm this. We're going to have this. We're going to have that. This may come that opportunity. Oh, and I think Nikki said something way earlier today about the comments about the, you need a lake house, or I need a lake house and you need this or whatever, in regard to Becky Hill. If that was conversations between two clerk of courts, kind of said as like a throwaway comment, oh my gosh, this is crazy. There's a lot of people here. Somebody should write a book about it. You'd get a lake house. Oh my gosh. You know, like, maybe they're saying it in jest. Maybe they're saying it playing around, or maybe they're not. If they're not saying it in front of the jurors and the general public, if they're saying it behind the scenes, I don't feel like it should be an issue. And I think those comments were taken a little bit too seriously for what I think actually transpired. Hey, Nikki. How are you,
Hey,
lady?
I was actually coming to like talk to you about that comment specifically, because like while
Yeah.
it drove me nuts, like hearing her say that, and like at the same time, like it holds no bearing over why they're in court.
I agree. I feel like they were trying to give it more weight to the fact that she really wanted there to be a guilty verdict because it would drive up sales of a book. But she could have said those things. She could have had those intentions, but if she didn't say it in front of the jury and if she didn't start working on the book during the trial, then I feel like it doesn't have any weight on the outcome.
Do we know when she started writing the book? Was it clear that it was after?
I don't know. I know there's been a lot of things said about it, including today at the hearing about when she actually started on the book, but I don't think it was actually proven. And again, I know the second clerk, Rhonda, said she did say something to me as the trial was starting, like, we should write a book. But there's no evidence that she started working or writing on a book.
Right.
1 second. I'm going to mute real quick.
Okay. Stephen, I heard about that, or I read about that story with the football game. That's wild. To my knowledge, though, like the friend's house that they were at, he wasn't involved at all. So, from what I've read.
I heard someone say in regard to what you and Stephen are talking about that perhaps the person themselves, like maybe there was some overdose issues happening, and then
I mean, it's possible, and they were outside, and it was. I'm not
well,
far
even the
from
guy
Kansas City.
whose house
Yeah,
they were at.
right. Well, and like the thing is like if there was a substance issue, like it was so cold that night. It was so cold that night. So if they
Yeah,
were out of their element, like it'd be really easy for something to happen and them not being
right.
able to respond correctly because of the substances. So,
Yeah, and if he were passed out or if he was ODing or close to it, he wouldn't be in the right state of mind or physically able to go check on them. I'm not saying that's what happened, but I'm just saying it was a point that was brought up that I didn't think about before.
right. Yeah. So during the break, Heavy and I went on a walk and we were talking
Yeah.
about this because I was telling him like what had all happened this morning. And he's wondering like if anybody can get into as far as like
You can go ahead and say it until she starts.
Please be seated.
oh, I'll tell you after.
Okay. Oh my god, I hope he doesn't get a new trial.
I hate his face.
Yeah, I do too. Why won't she just say it already?
In the matter of
Say it real
South
quick.
Carolina against Richard Alexander Murdaugh. 2022 GS 15-00592, 593, 594, and 595. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by clerk of court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influence the juror to vote to convict defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did clerk of court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.
Thank you, Your Honor.
Thank you. Let me say this, and I should have said it before I began my order. Hey, members of the audience, would you just be patient with me for one more minute? Please keep your seats. I have probably had more experience with trial and appellate work than anyone else in this room for many years. And it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they are a product not just of the attorneys who presented to me, but of the attorneys who sit with them and help compose the research and the writings that I received. I know that I put you on a very tight timeline, but my feeling is these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is, the appellate authorities who will decide what the standard in this particular matter is. I've not seen a case such as this before. I doubt whether our appellate judges have seen a case such as this before. And they will take a lengthy time to study the record in this matter, the record in the part remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it. And I will say this about the testimony that I heard Friday and today. Judge Newman said it best in his sentencing when he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the record, I say as the successor trial judge, I agree that the evidence was overwhelming and the jury verdict not surprising. This matter is now adjourned.
Woohoo!
I'm surprised. I don't want to say shocked. That's not fair. But the first few comments, I was like, oh no.
Yeah. Same. But she said both had to be proven, I guess.
Yeah.
For it
Yeah.
to be a trial. So, or a new trial, sorry. Wow.
So I was focused too much on his facial expressions when she was talking about what she was doing next. And I know Pickle commented on it. So basically she's leaving it back up to the Court of Appeals, right?
No. They have 4 days to make new arguments that perhaps were not brought, like if they discover any, like after they go through the transcripts. But my question about that is that a matter of law? Is that required, or is that her giving them some leeway? But it might be a matter of law. It might be something that if you are, if you have a similar situation to this, you're allowed to go over the transcripts, and then if there's anything incongruous, you can raise that again.
just feel like that's dangerous, given like Harpoolian. If you give that man
Well,
an inch, he's going to take a mile.
they can't bring up anything like it's not like a second chance. So my understanding is like they can't bring up anything new. They've already had the chance for that because there's no way for the DA to counter it.
Mm-hmm.
But if they see something that's incorrect in a transcript or, you know, not right, basically,
Right.
then they can say, oh, this was misinterpreted. Which, I mean, okay, you could say that about Becky Hill's testimony, but the others, you know, the second qualifier for an appeal, that was clear to me. That's clear cut. With 11 jurors saying no, we weren't influenced, there's nothing to be gleaned different out of that.
Right. The only one. So like two out of the 12 said that they heard the comments, or 2 or 3, but only one, and that was Jersey, said that they influenced her. But I think it was Meadows that was like, what she said that influenced her was more the pressure from the other jurors, and that's
which
going
is
to happen.
that's the way it. Yeah, that's the way it's supposed to be. You're supposed to come to a concise decision as a group, and if you feel pressured, that's on you, because you are bearing the pressure of, no, I want to debate longer, but I guess I'll go along with what the group wants. That's the whole point of a jury system.
You're supposed to take into account what everyone else is saying in the when you're deliberating only.
Yeah. Because there might be something you missed. And you know what, to be honest, if I was on a jury and there was one dragging their heels, I too would be like, come on, we have to make a decision. That's your opportunity to speak up and say, well, no, I don't agree with you guys. This is not right.
That's
or
why I'm
yes,
kind
I
of glad,
agree.
even though I'm kind of glad I didn't get to deliberate on the trial I was at, because I think I would have held out, just because I'm such a rule follower and according to the law.
Yeah.
We should have found this person not guilty on one charge that they had. Yeah, getting a new trial is very tough. Steven should know. He's a juror there. So earlier today, oh my gosh, you have not seen any of this pickle from today, other than hour.
Did you see this morning, early mornings part of this trial, Pickle?
GC tagged me and I was definitely asleep. So I popped in for a minute then because I was on my way to the hospital for pre-op. So I didn't see anything till I just came back in.
So this morning, the jurors didn't get their phones confiscated, and 2 of them were on their phones, one of them streaming the questioning of Jersey.
Oh my God.
And we weren't familiar with Steven, and he was in the chat this morning, so we were giving him crap that he's on the jury.
That alone,
watching a live stream of this in the courtroom, I'm like, oh my gosh, what if they were watching me? Very, but I was just being silly with it.
Well,
I mean, if I were the judge there, I would have been like, chuck it. I mean, I would have checked them out.
She was pissed.
She was pissed. She even said, I'm about to have a conversation with you that I don't want to have. I'm like,
right. She put herself in timeout. She's like, I need to go calm down.
Yeah.
Yeah. I figure that's probably not something that comes up, and it's probably not something comes up. When are you questioning jurors who have already reached on a trial?
No,
judge probably didn't think to tell them, hey, don't watch this as it's going on, because you typically take jurors' phones, but they're jurors, but in this situation they were witnesses. So it just insane.
Now, if I were Murdaugh's attorney, I would have said, obviously these jurors are not following the rules. This is evident now. They can't even do it right now. How can we trust? I don't know if he said that or not. I wasn't watching, but like I would have made a big deal about that. But see, they can't follow the rules here, and this is minutia compared to the whole trial. So how do we trust that they did it during the trial?
Mhm.
True, but that didn't come up during trial.
True.
That was the time to put it. Hey, Pickle, you don't have any like TV or phone going on in the background, do you? I can hear
Joey?
something.
Yes. My husband is like half asleep with his thing. Can you turn that off? Joey.
Does he fall asleep too? Ask him.
He's falling asleep and he's cranky. I was like, geez. There we go. Do you hear it now?
No.
Okay.
No. I can't read your avatar, Steven.
I just clicked on it. It said she beat it B. It's
She what?
It says
she's
she's a breast cancer survivor.
Lung cancer.
Okay.
Lung cancer. Sorry. I saw the pink ribbon. So
welcome to the club. It stinks.
Yeah.
I'm sorry you went through that, but I'm glad you're a survivor. And I hope everything is going okay with you, Pickle. I know you said you don't have to, say anything if you don't want to, but I know you're telling us you were getting a phone call from oncology. So
it was just pre-op stuff. They actually moved my surgery up. It was going to be at 9:30, and they had someone cancel. So now it's 7 a.m. And I'm like, okay.
Oh my goodness. Is that tomorrow?
No, it's the 8th. So what is the 8th? What is
week.
the 8th? Next week. I don't know what day.
Yeah.
Thursday.
Oh, Thursday.
Oh yeah, it's almost February.
Well, and then the whole I don't think Pickle was there for it either. So they called the egg lady juror, and Court TV showed her like walking in and everything, and they weren't saying her name or anything. And then Harpullian's like, so I'm assuming she's the same as the other jurors that were like not showing her. And JC's like, too late, we saw her.
Well, I thought it odd when he looked at the back of the court, like she was going to walk in through there, because I'm like, Sasha, stop. That the cameras can see the gallery, the cameras can see the back door. So I guess because she's not technically supposed to be considered during this, then maybe they're going to show her face. And then, and not only showed her, it like panned her walking through the courtroom and up on getting sworn in, and I'm like,
Good land.
Oh, wow.
Well, I'm thankful for the verdict, because hundreds of thousands of dollars once again were already spent, and I don't think anybody. Yeah. I don't question his guilt. I'm sorry. I question if there was someone else involved.
Right. I don't question his guilt either.
Yeah.
But I do appreciate the legal system working how it's supposed to, and the jurors not having external influence.
Yeah.
And not only not having external influence, but it not being by someone there at the courthouse that should more than know better. And I don't think Becky Hill should have a job there any longer.
No.
I don't think there's only one person that can dismiss her of her duties, technically. I don't think she can get fired. I forget how that works. I've been listening to a few people talking about it.
So I know Rhonda said that she was up for a re-election of hers. Does that mean that Becky Hill would be the same year? Would it be the same timeline?
I don't
And if
know
so,
it's
y'all need to vote her out. Like,
yeah.
get
Well,
her
I
out
can't
there.
because she's not in my county and district. So
No, I know. But still, I'm like, get her out of there. Jesus.
I'm several districts
I mean,
away.
I don't think she should be even allowed to run again. They should put,
No, I agree.
you know,
Especially after like today, like the stuff that she said on the stand, even if, she lied, didn't lie, whatever, in my opinion, she did. And on several occasions, she was a mess. But like the stuff that she did admit to and then
Yeah.
didn't admit to, like, and like when, I can't remember, McElveen, is that her, Rhonda's last name? When she was on there, she has, like, the judge said, or it was either the judge or the prosecution, was like, she had no dog in the fight. And she
yeah.
admitted that Becky had driven a juror home. Like, that stuff should not be happening. And I come from an extremely small town in a very small county in bumfuck Egypt. So, like, I get the small town aspect of things, but it's just not okay. Like,
There
No.
could have
just
been
not okay.
police officers that escorted them home with a bailiff present. But again, my thing is, I'm not saying it didn't happen, but it wasn't proven. And also,
Right.
if the president of all clerk of courts in the state knew about that and didn't report that to the
Yeah.
judge immediately, I
Mhm.
find something wrong with her credibility, just as a clerk of court, not even necessarily with her testimony, but just as a clerk of court. Like I'm sure you've got like an honor code or something to adhere to. So
Well, there has
I'm
to be,
report it to Judge Newman.
yeah,
Yeah.
there should be some consequences so it doesn't happen again. I don't remember the woman's name, but do you guys remember the case of the clerk of court who denied a gay couple marriage certificate, even though it was legal now?
Yeah.
And even though she had a bunch of support and support from like politicians and whatever, she lost her job
Mhm.
because she didn't do her job.
Right, you're not supposed to be biased
Yep.
as a public official. You're not
Yep.
supposed to show your bias. You're not supposed to do improper things, and that was improper. So
Yeah.
Well, and as Becky Hill herself said, that she was Switzerland. She should have been Switzerland. She was not Switzerland. Like,
Yeah.
not at all.
she should have definitely not let her opinion known to other people other than other court staff, like behind the scenes.
Yeah.
It's not improper for attorneys to talk about jurors when they're, behind closed doors, or
Right.
Mhm.
they can't go to the judge and sit there and bullshit and talk about the trial or the jurors or anything. But you know what I mean? It's like shop talk. That's allowed.
Right.
Right.
Well, and they confer and they say, like, if there was a true concern during the actual trial, the defense could have gone to the prosecution because the prosecution doesn't want to get a guilty verdict and then have it come up as a
Right.
new trial.
Mhm.
So the defense, if they had any concerns, should have gone to the prosecution and said, hey, this is going on with this juror. We suspect, da 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 da. They would have dealt with it then.
Right. I do find it curious. I think I finally kind of pieced together the whole egg juror, why Becky Hill would have had more interest in her being dismissed.
Mm-hmm.
It made more sense today when they were discussing when it was that juror was made aware the Facebook post existed and that it was an issue. That should have been the judge calling her to his quarters and
Mhm.
discussing it. But Becky is the one that told her first, based on the testimony we just heard. So
Yeah.
to me, it seems like Becky kind of brought it up to her.
Mm-hmm.
And the juror kind of was like, oh, yeah, well, that's my ex-husband or blah, 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 kind of confirmed it. And then Becky took her to the judge then after confirming it. So,
Yeah.
again,
And I think
it's
to
said
a lot of
that Egg
Sorry.
Lady was a plant from the defense and that she was going to rule not guilty no matter what. So if Becky caught wind of that and wanted that person out, so then there would be more chances of a guilty verdict and more sales for her book and da 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 da. So I did kind of connect those dots today.
Well, and I think like Steven said earlier, and I agree, like the sales for a book would have been good regardless of guilty or not guilty. Not guilty, maybe even more, because like all the evidence, I feel like she probably would have sold a lot more books with a not guilty verdict, in my opinion. But like, as far as that type of stuff happening, it seems so familiar to me. It's wildly unprofessional, but it's not shocking to me because I'm from such a small town. Like I know, like gossip is wild. Those Facebook groups exist. Like the stuff that gets said on there is wild. Like it doesn't shock me at all. But
the Facebook group.
Yeah, that because word of mouth. It was a town name and then like word of mouth, and which to me, we have a similar group for my area, but I know it's toxic as if so. I don't.
Yeah. I mean, we've seen jury impropriety before. If you guys remember the Scott Peterson trial, the first one. We're not talking about appeals now. The redheaded.
Did you hear that
juror.
He's on Innocent Project now?
I agree that he should have a new trial. I agree that he should. It's not about guilt or innocence. He should have a new trial. He said so many things. That juror, the one with the super red, they called her Strawberry, I think.
Oh, okay, yeah.
She lied on her jury application that she had never been a victim of domestic violence or anything like that. And it was discovered a couple of years later that she had not only been a victim of domestic violence, but had gone and testified against her abuser in court. That alone should have, in my opinion, given him the opportunity to have a different jury pool.
So, JC, I know you were just recently on a jury thing, and I was called for jury duty right after you served. And I got an opportunity to be on a jury, but then I was not chosen, and I feel like I know why I was not chosen. But I'm curious if your states do it differently. So, like, when I was given my summons, in Minnesota, you go online and you fill out, like, all this stuff. But there's no, like, are you a DV victim? Are you an SA victim? There's nothing like that. It's basic general stuff. And then when I got to the jury that I was selected for, and we were literally put in the jury box and we were asked questions by the prosecutor and the defense team. Then they go over those questions. And I feel, to me, that was, I guess I could kind of understand. I mean, I didn't, but I could kind of understand someone maybe not saying the whole truth or lying then, because it's extremely intimidating to have somebody, well, at least for me it was, being a victim of something like that in my past, to be in front of somebody that's accused of it, and then you're getting asked those personal questions and like giving details about those things that are, it's triggering, to be quite honest. And I remember telling my husband when I went home, I'm like, wow, like that got wildly uncomfortable. And I was really glad that I didn't get picked, because I'm like, that just was too much.
Yeah.
It depends on how many cases, because if they have 5 or 6 cases coming up, they send out summons, like they're random, it's a lottery.
Mm-hmm.
And then they don't know which case they're going to assign you to until maybe a day or before or so. So when you come in, you may be in a theft case in which if you're a DV, victim, then you could still serve. Whereas if it's a different kind of case, maybe that would disqualify you. So they have to question
Right.
at that point. But I agree, they could kill 2 birds with 1 stone asking that already. And then, there's the computer. It's not like back in the day when they had to hand do stuff. It's all
No.
computers. It can be programmed
Right.
to put people in different pools. Yeah.
I mean, there could
Yeah.
even be check boxes
Carolina.
like, do you have this in your history? Like, and there could be a DV, a sexual assault, like all these things that you can click, and that might take you out,
Yeah.
or put you in a different category that they could later, choose from
Yeah.
if you have enough.
Yeah. I have a friend who is a felon and he gets called for jury duty like once a year. And he's like, I take the time off work, I show up, and I'm always disqualified. And I'm like, I don't understand why they don't know automatically that
Right.
you are not qualified.
Yeah, I think you're supposed to write on, we were supposed to write things like that on paperwork, very general, like, is there any reason why you can't serve? And this was supposed to be turned in like at least a week beforehand.
Mm-hmm.
So that the powers that be, being that the clerk of court, could take that into consideration.
Yeah.
Well, my state switched it now, so like you serve quarters. So when you're given a summons, so I got my summons in July, and my quarter was the beginning of August till the end of November. And I could have ended up serving multiple juries. And there's actually people that were summoned at the same time as me that did.
Yeah.
Yeah, it depends on what kind of case it is too, because if it's a big case, like these jurors will not serve again for a length of time because especially
if you
if
serve
I get a
10
jury,
days, if you serve 10 days and they don't, you're done.
Yeah.
I don't know if it's
I'm gonna
different.
end up.
Sorry, go ahead.
No, I was gonna say I'm gonna end up getting a jury summons on like February 9th, and I'm gonna be like, nope, not happening.
Here's my doctor's note.
You'd still have to show up that day, though.
Not happening. No, come get me, please. Bring the ambulance with you.
Having major surgery the day prior, so
just got my guts cut open. I don't think I can show up.
Give me a Zoom link. I'll show up from Zoom.
Yeah,
right. Laid up in the hospital bed. Our judge, and again, it's a different county, it's a different district than where people served for the Murdaugh trial, but we were told 3 years we didn't have to serve. However, that was only for county. So if I get called for anything federal in our state, I would have to serve. So,
did Murdaugh get a change of venue, or was he in his home county? Oh yeah, because the judge said like I've practiced with you in this actual courthouse. I do disagree with that.
It wasn't in the same county, but it was in the same district. It wasn't in the same county that the murders occurred.
Because it's Hampton County is his home county, and then it was in Carleton County, correct?
See, this is what I don't understand, because everyone keeps saying Carleton County in regard to where it was, but it was called the Hampton County Courthouse. So
they could have redrawn the lines later after they named it.
Oh, that's true.
But I do think he should have had a bigger change of venue. Then there could be no impropriety. Like,
I mean, if it could be done, it should have been another state.
The courthouse workers for sure, and I mean, not even so much the jurors, just for that work there in the legal system. I think I shared with you guys before that when the trial was going on, the Murdaugh trial, that I went in had my car worked on and my headphones weren't working. And so I just had it playing on my phone. And there was a gentleman beside me that asked me if I was watching the trial, like while we were sitting there waiting for our cars. And I said, yes. And he said he was a prosecutor. I won't tell you what county it is, but it's close to where I am now. But he said that he went to hear a speaking engagement between attorneys down there in Beaufort and heard the father of Alec. He was the keynote speaker and said that this guy was spewing like BS, like used car salesman stuff, and that all these other attorneys were just like eating it up. And he kind of looked around and was like, oh my God, this is the legal system in this area. This is who is influencing it. And you could tell.
It's good old boy stuff.
Was he a transplant? Do you know that guy that you were talking to? Was he a transplant, like not from the area originally?
He was not from the Low Country, but he is from South Carolina. So he wasn't from that area. He's from up here in the upstate.
From everything I've read that you led me down the rabbit hole of, I mean, that family has to, I mean, obviously there's a lot of good old boy stuff, but there's also a lot of like charm and way with words and manipulation that goes on. Because, I mean, I'm just like, some of it, and you know, like when you think about like the victims that like of the all the insurance stuff that he's been a part of, I mean, you just lost a family member, you had this happen, and you have this big well-to-do known lawyer in your area saying like, I'm going to get you this and I'm going to get you that, especially as a female. I mean, I'm a little bit more feisty and pretty smart, so, but some of these other people might not be.
Mother and brother.
Yeah, and you know, and I can't say that I wouldn't in have putting myself in their situation, but like when they're so vulnerable at that time and they have this person in front of them saying, I'm going to hand you the world, like it's no wonder that they trust them.
And you've seen them, what you think is take care of people, but little do you know they haven't received their money or received very little. Yeah.
There's no restitution for the family of the housekeeper. Like, I know that he's supposed to pay restitution or give them that money back, or the insurance company the money back, but like he doesn't. What does he have?
Well, so here's my thing. Like, I don't like, so there's been like news articles about like how Buster's still living a lavish lifestyle. I don't want to call this lifestyle. Like, where is that coming from? Because
he did get money from the estate,
but in my opinion, there shouldn't be any money for him from that estate.
But he doesn't have anything to deal with it, and it was his mom's estate. It wasn't Alex, so that's where it gets tricky.
No, I know. I guess I just have other opinions about Buster's involvement. I don't think he's innocent.
And Alex's name, the Moselle property was in Maggie's name. Same with the
I think Buster didn't know anything beforehand.
I think he knows stuff now.
I think he knows stuff now, yeah.
Yeah.
Because he's pretty disgusted with his dad. That's come across very clearly.
Is he?
Yeah. There was conversations that were recorded between them after the conviction, and Buster is not. He's just very like, yeah, okay, whatever. I gotta go. Bye.
What about that one interview though that he did right after the trial? I can't remember what news channel it was on.
I mean, it behooves him for his father to not be found guilty. So, you know, and there's love. I'm sure, like, if my dad did something heinous, okay, dad's not a good example for me. If my husband did something heinous, I would still be out there, like, you know, repping for him. But privately, I would probably be like, you know, grr.
I mean, I guess it would depend on the situation. Like, I think too that that current situation with like the Gilgo Beach killer, like with his wife, like
The what?
the Gilgo Beach serial killer in New York,
Long Island.
Long Island, New York. Yeah, the one that just got like arrested after how many decades has it been? 2 decades?
It started in the 70s, the early 70s, didn't it? Or the early 90s. You say 20 years ago, and I'm like, oh, the 70s. No,
No, I know. It was at least the 90s, but there was like
there's several victims, a child and a man, but mostly women in their 20s to early 30s, and they've tied 4 now to him.
Well, then there was just another name released.
Yeah,
I think
like
yesterday,
4 days ago.
Yeah, something recent. So, but it's just crazy. Like, but he's got a wife and 2 adult children, and I mean, there has been some discussion on the wife's involvement, but in my opinion, unless I see otherwise, the wife and the kids were out of the country. So that kind of
and if you look at Dennis Rader's daughter, she's like, we had no idea, and he was doing this in our home, and we had one of the blankets he took from a victim, he used it on a camping trip with his kids, and they slept with that blanket.
Yes.
But like, I think of like how their reaction, like they've denounced him. They said that, you know, it's disgusting to them. So like for me, and then I think about Buster, who isn't doing that. And I'm just kind of like, for me, I mean, I don't care how much I love, and then this is going to sound harsh. I don't care how much I love you. If you took my mother and my sibling away from me,
correct,
and that's proven in court, I wouldn't defend you. And with the evidence being as overwhelming as it was, I wouldn't even support you in court. I would be sitting on the other side.
Yeah.
It depends for me, because like I've had conversations with my mother about things, because I'm that person that has to be like, what if I did this? What if I did that? And I know how my mother is, and if I were to off someone publicly, she would 100% have my back, even if she knew I was.
Different with a parent and a child versus a child to a parent,
especially when another parent is the victim.
Took another parent from the child.
Yeah. Right. He may not know. He may have doubts still. He may not even realize, like, there's a denial level there. Like, no, my dad wouldn't do this. But I think he does believe the financial stuff because he knows about the addiction issues. But yeah, I'll have to find the video and send it to you. But it was like Crime Daily or something. But they had might have been Long Crime, I don't know. But they had the recording of the phone call, and he is not happy with his dad. He didn't like cuss him out.
That doesn't add up for me. Like, I know that it was a substantial addiction issue, but like, we're talking like millions and millions and millions of dollars.
I don't understand how he, like, when he said how many pills a day he was taking.
I believe that to be true.
I was like, there's no way that
you were
functioning.
Yeah.
Yeah. Does he have a secret mistress and a child?
I even believe that there was any sort of addiction, even if it was just a handful of pills a day, is because of Paul's ex-girlfriend, who was in the first season of the Netflix documentary, because she said she saw it with her own eyes. That's the only reason I believe it. I don't believe
Is there another
anything
season?
anybody else. Huh?
Is there another season of that series?
Yes, and Becky Hill is on it. That's why the whole Netflix thing got brought up today.
We're gonna have to watch that.
Makes sense. Yeah, we are gonna have to watch that.
For me, understanding addiction and having worked in the field and having, people in my life, the thing that gets me is that he's taking all these pills. I mean, from his testimony, 50, 60 a day. I didn't see any withdrawals. There was no commentary on him going through withdrawals. There was no, like, it would have come out if he was going through withdrawal, substantial withdrawal in jail. We would have heard about it, because like the Delphi murders, that guy right now, they're talking about his mental health and how much, we've all seen how much weight he's lost since he's been in jail. There was nothing.
Yeah, that's a question for me, because in my opinion, he would have lost weight on them. Not,
Yeah.
and he's a big guy. And to me, like looking back on pictures that, has been put up through that podcast, like it only consistently seemed like he was gaining weight until he went to jail, and then he lost a bunch of weight.
Yeah. Murdaugh looks like he's thinner, but his color is good. He doesn't look any different in his face and his color than he did during the initial trial, or the, arrest. Like, I just have a hard time believing that he had such a substantial addiction.
Right.
When I didn't hear anything.
I believe it was a factor, but I don't believe that it was as bad as he is claiming it to, at least as far as like he's claiming that that's the main reason. Yeah.
Yeah. And you're not getting those kind of medications from any doctor anywhere at this point, legally. So he's got to be getting, buying his medication on the street. And I never saw anybody come forward and be like, not that they would willingly come forward, but like,
you haven't gone deep enough, my friend. Have you not heard about the whole running situation, Operation Jellyfish? Did you not hear about Operation Jellyfish? Yeah, girl, this goes deep from like drug stuff from the 80s. This goes deep in the Moselle property. The previous owner was a known drug cartel person. That's why he got the property for like $2 or $5 from his bestie. Yeah, girl, this goes deep. I know, and everybody's saying like, yeah, blah, 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 blah. There's so much more I wish I could say. Not that I know. I just don't want to get
see.
Too much
then that opens me up to wondering if he was meeting someone on the property that night, and they were down there, and the person showed up and was like, boom, 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 and it's all a drug thing.
But there was nobody else there, so.
Yeah, I personally feel like somebody else was there. I think even if it was a contract, I think somebody else was involved. Not that he should be let go, but
Yeah. I believe he is found guilty, and I believe that's a great verdict.
Yeah.
I agree.
Because in a lot of, like, let's say it was a drug deal gone bad, and that's what happened, and they showed up and they were mad, and so they, did whatever. Even that would have gotten him a life sentence in, I believe, South Carolina. It does have that statute where if your murder was committed in the course of felony behavior, you are just as culpable as.
There are certain situations that have to occur in order for that to be a charge that is brought up. It's called a hand of one is a hand of all, and there has to be conspiracy that is proven, conspiracy beforehand to commit the crime. There has to be proof that they were there. There has to have a violent crime had to happen, which obviously it that was part of the conspiring beforehand to commit that crime.
Yeah.
There has to be a lot that has to happen. It just can't be any kind of, like, if you're here with someone and they commit a crime and they have a gun or whatever, like a felony, it doesn't mean you're automatically guilty. There's certain stipulations that have to be present and you have to be found guilty of, and that's the type of trial I was involved in. It was a murder trial, and the hand of one is the hand of all law came into play. I wasn't even aware of that until our trial. So
Yeah. I know in Illinois, like if you, let's say Nikki asked me for a ride to the bank and I don't know anything about it.
right.
And I take her to the bank and she jumps in the car and says, I just robbed the bank. We got to run. And I don't call the police.
Mhm.
Even if I go to the police later, I could face, and I'm not in Illinois, I just know this to be true. I could face prosecution.
Yeah. There's like accessory after the fact.
Yeah, but in Illinois, if like say she shot somebody, Nikki, don't be shooting no people. But if she
I
shot
was gonna
somebody,
say, but what's your answer? Are you calling the police or not? I didn't know if I need to take you off the list.
right?
Like,
Especially, and that's my problem with the law. To be honest, is if you jump in my car and say I just killed somebody, we got to get out of here. I might be in fear for my life.
right.
Like,
Right.
so how am I going to jump up and call the cops? There was a case where a woman went to the cops after and said, I know who did this, and this is how I know. And someone had been killed in commission of the crime, and they held her accountable. Now, she didn't get, felony murder. She got, I believe, a second-degree charge.
Yeah.
But still, and she was found of lesser. Like, she did get punished, but she got a lesser
Right.
offense. But, like, still, like, how can you do, if someone gets in my car with a gun to my head, I'm going to do whatever they want me to do.
Right, because you're in fear for your life. I
Yeah.
would assume that should be taken into account, but I mean, I
But
guess
when
it
you're in the
depends
hands of a jury, they do what they want.
or if you went 5 minutes later, I don't really know.
Well, I think the stipulation in her case was that it was a known person to her and she knew that they had a questionable history. So they were like, why would you associate with this person? It wasn't like she was kidnapped,
Yeah. That's crazy. Nikki, when you were talking earlier about going through jury selection and them asking questions, we didn't get asked as many detailed questions. We went through 2 rounds of stuff. One was in like a big, I guess, the jury assembly room, like where everyone just reports to. And then a lot of us got called up. I can't remember now if it was all of us. A lot of us got called up to the courtroom, and all they did at that point was say our names, which infuriated me. They did not refer to us by number. They said our freaking name, my first and last name, and there's a person that's accused of murder sitting right there looking at me when they say my name, and I have to stand up. And basically the state was like, or the judge said, hey, state, what do you think about her? And they're like, yay. And they're like, hey, defense, what do you think about her? They either said yay or nay, and then we went up in the box. They made their biggest decision on who they were going to select when we were all downstairs. And we did have to stand up and say something then. We had to stand up, say our age, our occupation, whether or not we were married, and if we were married, what our spouse's occupation was. And again, I got to talk to both attorneys, myself and the other alternate got to hang out there in the courtroom for quite a while they were deliberating, and talk to the attorneys on both sides. And the defense attorney was like more chill and willing to talk to us. And he was asking us a lot of questions. And I finally was like, cool. All right, I'm going to flip the tables. Like, I want to ask you questions. What about me made you pick me? And he told us certain things, and it was basically just off of those simple, quick answers that I had to give. And it was more based on my spouse than it was me. So I found that funny. But,
That
Yeah,
is
that was something that bothered me actually, because so for
Yeah.
mine, it was a DV sexual assault case, with also added charges of witness tampering.
oh, wow.
And that made me nervous. And then there was
Sure.
also some, for me, like when I got there, there was some resemblance to somebody I have known previously. And so
Yeah.
it was just kind of like all at once. And so then, like, they're saying my name, they're asking questions about, you know, my history and, um, not super detailed, I guess, about my SA, but like enough that I'm like, wow, there's a whole lot of people in this area that I don't really want to have all these details. Because, I mean, I haven't even discussed that with some of y'all that are really close to me. Like, that's not something I talk about. So, like, it was just super personal. And then, like, you're bringing my spouse into it. You're asking, like, his name and what he does and where he works. And it's just kind of like, okay.
You're
It was a
totally taken
lot.
off guard and like, holy crap, I'm going to have to answer this question and then I'm going to have to answer it truthfully. Like, I can see someone getting flustered and you're being stared at and it's a serious situation. And
Well, I told my husband I felt so hot because, like, not only that, but like I felt like I was on the defendant seat in a way, because
Right.
you're in the being questioned by prosecutor, the judge, and the defense team. What meanwhile, this defendant that is resembling somebody in my past is staring right at me and
Right.
is learning all this personal information. And I'm just kind of like, I don't want you to know this. I don't want to talk about this. There's bright lights above you in the jury box. And I'm kind of like, I cannot do this.
Right. Yeah.
And that's coming from someone that was genuinely excited to be on a jury because I like this stuff. Like, I'm very curious about this stuff. But it was, yeah, not a great experience.
No, it's not the same as sitting there and watching it. I know, like, too, whenever we got selected and we had like lunch right after, so that was weird in and of itself, because it's like we're all kind of in shell shock and we walk out on the street and we're all like, okay, we can't talk about with each other, but also like, where do you want to go for lunch? And like, what are we doing here? So then we come back in that afternoon and go back to the jury room. Like, we'd been through the courtroom already, but we had gone through the same doors the general public went through. But this time we're just like walking down the hallway for the jury room. And I'm thinking, like, when the bailiff opens the door, like, there'll still be like another room or another hallway before we're just
with everyone
out on display. And nope, you're walking down a normal office hallway. They open the door and then all of a sudden there's a courtroom full of people. There are reporters, there are cameras, and of course we're not on camera, but still it's like, holy shit, the news is here. This is that kind of a place. You know what I mean? Thankfully they were only there for that day, but still, I'm like, holy crap, you're just like, and then all of a sudden, to begin with, they start playing the 911 call of like the incident that happened. And I'm just sitting there and I'm like traumatized. Like, you know what's going to happen, but when you're physically put into all of that, you're like, holy shit, this is super intense. And yes, all of it was interesting, but emotionally, I don't feel like there's enough advocacy, if you will, for the jurors and being a juror. Again, there was a time where me and the other jurors were coming back from lunch and we were in the same parking area where we were told to park as the general public, to include the family of the victim. to include the family of the victim, one was present for the crime, who testified, and whose family is kind of realizing, oh, there's the jurors right there. And they're kind of slowly walking toward us. And sure, they're not supposed to talk to us, but when you're alone in a parking garage together, and they want this dude to be found guilty, I was like, holy crap. And thankfully, me and the other alternate, where I was like, there's a door, there's a door, there's a door. We found like another way really quickly. But that was insane. We did get escorted out after the verdict was delivered. But even everything beforehand, I'm like, oh my God, like, when you are a juror, you do get, and this is where the confusion to me about Becky Hill having so much opportunity to be alone with the jurors, I found disturbing. None of us were allowed to go anywhere without the bailiff, except when we were let out for lunch. And even when we were let out for lunch, we had to wear a tag, our juror tag on us, not with our number, but it said we were a juror. So that way,
people wouldn't talk to you.
Right. So we wouldn't talk to. So if we accidentally walked in the same restaurant as the judge, which one of the jurors did, the judge got up and left. So
well, and so for me, I wasn't selected, but like even with me, so there was the court clerk, the Becky Hill, and then there was a deputy Becky Hill, and then there was two bailiffs. Because I remember before we even, while they were still like dealing with stuff inside the courtroom before we were brought in to be questioned, I had to go to the bathroom, and there was two bailiffs, and I didn't even go to the bathroom by myself. Like he walked to the bathroom with me and stood outside the door, and I wasn't even selected yet.
Yeah, that's.
I have to drop, my dears.
Yeah, I gotta go soon too. So.
Well, I'll probably wrap it up in about 5 minutes here, but thank you guys for coming up here, talking, chatting.
Yeah, of course.
It was a wild day.
Yeah, I'm so super freaking happy that he was not awarded a new trial. Not based on this. I definitely feel like Becky Hill needs to be under a lot of investigation. I mean, there are two active investigations going on with her right now, and her son was arrested for and has been accused only of wire tampering at the courthouse. So, you know, there's that. But yeah, good times. Definitely think all that needs to be taken care of for sure.
I will say that that county or that area has some. I like Judge Newman and I like Justice Toll, so I mean, they were fun. And Pickle, if you don't watch anything from earlier today, go back and watch Rhonda McElveen's testimony. She's a character. You'll enjoy it.
I'll have to.
She's definitely a character.
Yeah.
All right, guys. Well, I'm going to go ahead and end the stream. Again, thank you for being here and chatting. I love this kind of stuff, and I'm so glad that he doesn't get a new trial, at least not today.
Not
All right,
today,
bye,
at
guys.
least.
Bye.